Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. Let's go ahead and start our morning in Miami-Dade with Judge Glazer.
Armed trafficking and oxycodone.
Narcotráfico a mano armada de oxicodona
And possession of cannabis less than 20 grams.
y tenencia de cannabis de menos de 25 gramos.
Your attorney is in court today. Please state your name for the record.
Su abogado está aquí presente y se le está solicitando que indique el nombre y apellido. Counsel, you're going to need to allow me to interpret for your client unless you're waiving.
I'm sorry, it's nice to see you. We'll hear you. Brandon Gonzalez on behalf of Mr. Castro.
Ray González a favor del señor Castro.
Thank you. Counsel, Mr. Gonzalez, do you have any argument regarding probable cause?
Your Honor, I do for the element of armed. I don't believe there's
¿Tiene usted, señor González, algún
Let's give a pause for
argumento
her.
en cuanto a causa probable?
There's nothing linking the firearm to our client, Your Honor.
No hay nada que vincule la arma de fuego a mi cliente.
He's saying there's nothing linking the firearm to their client.
Él está diciendo de que no hay nada de que vincule el arma o armas a el cliente de él.
So they observe him do a hand-to-hand transaction with narcotics.
Lo observaron haciendo una transacción de mano a mano de narcóticos.
So the gun was in a bag that he had around his chest. I believe there's
El arma de fuego estaba en una bolsa que él tenía alrededor de su torso.
And then he dropped the firearm onto the passenger seat, and the narcotics were recovered in his
Luego él
bag.
dejó caer el arma de fuego. He let it drop to where, Your Honor?
On the passenger seat of the vehicle.
En el asiento de pasajero del vehículo.
And then they recovered narcotics, the fentanyl, oxycodone, MDMA, or 2C, and cannabis.
Y luego fue cuando recuperaron el fentanilo, la metadona, el oxy y el cannabis.
That was in the cannabis was on the center cup holder, but the other drugs were inside the same bag where he pulled the gun out of, it looks like.
El cannabis estaba en el portavasos en el centro y el resto de los narcóticos estaban en la bolsa que él tenía.
Yeah, what gun was found? The passenger seat. It's not his vehicle. I don't believe getting knowledge that that gun was there.
No se le oye a su abogado, así que no le puedo traducir.
State, he's saying he didn't, it was in the past, it says it's in his wingspan, it's in his proximity.
Está en la proximidad de él.
He also reached into the bag that he had around his chest and proceeded to pull out the firearm.
Él también indica acá que él entró en su bolso que estaba a distancia del brazo o mano y sacó el arma.
So I understand you're making a good argument, but I believe there is probable cause for the charge.
Yo sé que usted está haciendo buenos argumentos, pero dictamino que hay suficientes indicios de criminalidad para los cargos.
As to count one, armed trafficking and fentanyl, the state filed a motion for pretrial detention pending final hearing.
En cuanto al cargo número 1 de narcotráfico a mano armada, la fiscalía ha entablado una petición de detención preventiva previo a audiencia.
There's probable cause for armed trafficking and fentanyl. He had 8 grams of fentanyl. The threshold for trafficking is 4 grams.
Y él tenía 8 gramos de fentanilo y el umbral es 4 gramos. ¿Hay suficientes indicios para ello?
And because it's armed trafficking and fentanyl is considered a dangerous crime, I have to grant the state's motion for pretrial detention.
Y debido a que fentanilo se considera un narcótico bien grave y peligroso, tengo que otorgar la petición de la Fiscalía de prisión preventiva.
All right, state, how many grams do you need for trafficking and oxycodone?
¿Cuántos gramos necesitan para oxicodona, fiscal?
7.
And he had 16 grams of oxycodone pills. The trafficking threshold is 7 grams. So there's probable cause for armed trafficking in oxycodone. That's no bond, but that's pursuant to an Arthur hearing.
Él tenía 16 gramos de oxicodona, el umbral es 7 gramos. No hay fianza en eso según una audiencia Arthur.
He had 13.2 grams of a drug called 2C or MDMA. That's MDMA with cocaine. It's pink cocaine. And there's probable cause for possession with armed possession with intent to sell I
Él
think I
tenía
got
13.2 gramos de TUSI o MDM o cocaína rosada con la intención de venta.
I made a mistake, corrections. Count 2 is the MDMA, it's armed possession. He's charged with trafficking in it as well. Oh, that's also no bond pursuant to Arthur.
Según la Arthur, eso también es sin derecho a fianza.
And then possession of cannabis, there's probable cause for the charge. Yeah, 10 grams. I'll set it at $1.
Y la tenencia de cannabis será de 10 gramos. Esa fianza será $1.
So, sir, you're gonna have to go see the division judge tomorrow, who is Judge Altfield, and he can set a final hearing on the state's motion for pretrial detention.
Que mañana será llevado ante el juez Outfield, que es el juez de división, y él fijará la vista para su...
Do you have anything else?
Judge, I just wanted to say something to the private attorney. It doesn't need to be translated. I got 2 emails from 2 different private attorneys on this case who said they were retained. So I don't know if you want to figure out who's going to be representing the defendant long term.
Was it Cruz and Justin Beckham? Eric Cruz, Justin Beckham? They have a law group.
Yep.
Yeah, same people.
Okay.
You're working now with Justin Beckham? Oh, that's nice. He used to be the PD in my courtroom in when I was a judge in juvenile many years ago. I think I swore him in too, the Florida bar. He's a very good lawyer.
He's a great person. So is Eric Cruz. I'm very lucky.
Well, good. Okay, well, good. I'm sure I'll be seeing you a lot.
Thank you.
Thank you. So, sir, you have a good attorney. Listen to what they tell you.
Si no tiene buen abogado, escucha a sus abogados.
Thank you.
Okay, moving right along. We
Another
have the,
private attorney who's waiting, just so you know, on page 7, number 22, Randy Dotterai, whenever you're ready to call. He's been waiting. He's added to the list for some reason. He's been here a while.
who is it?
It's a Randy Dotterai. The lawyer is Joshua Alexander, page 7, number 22.
Page 7, number 20. I'll call it. I got to move along quick. I'm going too slow. Let me call Randy Dorai. Is he there, corrections?
He's here, Judge.
All right, page 7. Can I have that, please? Oh, I have the papers here.
The last one.
I gotta find page 7. I got 25 pages today, which is a good 3 or 4 hours to get through this. Okay, let me find it. I got it. Did somebody promote the attorney?
I'll promote.
Thank you. Good morning, Mr. Dodorai. You were arrested for aggravated assault with a firearm, unlawful discharge of a firearm in a public or residential property, and criminal mischief. This is a case from January 8th of 2023. Your attorney is here. Is it Mr. Alexander? Did somebody promote him?
Trying.
He has to raise his hand on Zoom and we can promote him.
Please accept the promotion.
May not be there. Or is he in another courtroom?
Let me try again. You need to accept, please.
I'll do it. Is Mr. Alexander there? I don't know where he is. Mr. Alexander, are you there? He was here at 10:05, which was only 6 minutes ago. Okay, I don't know where your lawyer is. This is why I have to pass it, and this is why I get delayed. Let me pass it. He's in another courtroom, so he'll come in when he's ready. Next, we have out of turns for correction, starting on page 5, Levinsky, John Vier.
Well, the next contestant comes up. Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Thursday. If you haven't already, go grab yourself a bingo card, tcfbingo.com. Play along while we watch. The most interesting thing for me so far is that Glazer used to be in juvenile court. That was either brilliant or frightening. I'm not sure which. Let me know your thoughts in the chat.
Public Defender's Office for you. So he's stealing items from the Dollar Tree, $19.91. It says he has more than 2 convictions for theft. There's probable cause for the charge. You are ordered to stay away from the Dollar Tree store at 13490 Northwest 7th Avenue in North Miami, Florida. You are not allowed to go to that store and you must stay away from there. Do you understand?
Yes.
Thank you. He
Just
has,
ask for the TAP program for Mr. John Vier, currently homeless. If you utilize
Request,
services of the TAP program.
requesting a bond. I see a petty theft conviction from February, a trespass conviction from February, a trespass conviction from, what is it, the 18th, so that would be earlier,
2 days ago,
This
3
week.
days ago.
right? And then he has a 501-day sentence from last year.
He's a signal 200. I'm setting a bond. Your bond will be $1,000. Stay out of that dollar fee. Have a good day. Next, we have, I'm recalling Mr. Dodore on page, what was it, 7 or 5? I forgot. Page 7.
six.
Page 6 and 7. Thank you.
Thank you. Good morning, Your Honor.
Good morning. So, Mr. Dodore, you were arrested for aggravated assault with a firearm, unlawful discharge of a firearm on public or residential property, and criminal mischief. This is from January 8th. So, Mr. Alexander, anything you care to say regarding probable cause?
Your Honor, regarding probable cause for the aggravated assault, there was no indication that she was aware of the firearm being pointed at her, or that when the threat was conveyed, that she had any knowledge that there was a firearm. The only knowledge of the firearm came out later when it was shot into the ground and into the porch, not directed at anybody and not placing anybody in fear of imminent danger at that time. So I'd argue there's no probable cause for count 1. Also, Your Honor, I would note, of course, this is over 2 years ago now. The two reside together and have had another child together since this incident. I'm virtually certain that the alleged victim is not going to want to go forward and prosecute. I don't think they even knew that this still existed or was out there, Your Honor, because Mr. Dodore has been living crime-free with the alleged victim for well over 2 years at this point.
Is she here today regarding the stay away order or no?
I did not have an opportunity to contact Your Honor. I was not provided with her contact information.
Okay,
There's PC on the assault. It says,
go ahead.
right, he re-entered the house armed with a gun, said to the victim, "I'm gonna do your ass," while holding the gun.
The witness is the one who didn't see him with the gun.
Defendant is on probation until 2028, but this predates
Where in here or in
Broward.
Broward?
Howard, Your Honor, but yes, this predates that case.
All right, so you were ordered to stay away from the alleged victim, even though it happened in 2023. I'm still required to do a stay away order unless you want me to pass it to see if she wants to come in,
If
and I'll
we
be
could,
happy to
Judge.
do so. Yeah, I
Thank
can
you.
pass it. Let me know when you're ready.
Do you want to pass
call
to
it.
the afternoon's calendar to give me enough time and that way I don't delay the court?
Oh, you're not going to delay me. I got a 25-page calendar. See,
Okay.
if you can get her this morning, it's better. I don't want to reset anything.
Thank you, Judge. I'll see what I can do. I
All
appreciate
right.
it.
Sir, I'm going to pass the case to see if your attorney can get in the victim to see if she wants to appear regarding the stay away order, okay?
Thank you, Judge. I'm going to go to some other Zooms while I'm making the call.
No worries, no
Alexander,
worries.
Judge.
do you have her phone number?
No, I do not.
I'll send it to you.
Thank you. That would be great.
All right, next we have hold him up corrections. Erlen Roman, page 5. We're back to the PD cases, I think.
Mr. Roman has a fugitive hold from Palm Beach County and a probation warrant, both no bond.
Okay. Good morning, Mr. Roman. You were arrested for a case from June 5th of 2025. The charge is fleeing and eluding a police officer, resisting an officer without violence, and I will appoint the public defender's office for you. So he was pulled over by the police. He said his name was Larry Mercedes. And while verifying the information, he then accelerated and sped away. The police used investigative means to find him, and then he was arrested yesterday, and the officer immediately recognized Mr. Roman from the PC flyer. So there's probable cause for fleeing and eluding a police officer and resisting an officer without violence. He also fled on foot, so that's the resisting without. I'm setting a bond. Count 1 is $2,500. Count 2 is $500. Have a good day. Next case we have is Tavares George on page 7. Usually we're in courtroom 1-5, but they're redoing the electronics. I don't know if we'll ever go back because they've been working on it a while. We move around, we're like wanderers, but we're here now. But the other courtroom, they have big cameras, you can see everything. Hi, Mr. George, good morning. You were arrested for fleeing and eluding a police officer. I will appoint the public defender's office for you.
Judge, I have argument on the fleeing and eluding.
Go ahead.
Just there's nothing indicating lights and siren. At best, it would be resisting an officer without violence for running, but not for the felony. These are red detectives.
State, I think she's correct. Where does it say?
Just give me a sec.
Where does it say that it doesn't mention they had their
marked.
lights on?
No.
He noticed the marked police vehicle and an unmarked, I'm sorry, he noticed the marked and unmarked sped up and began fleeing. It doesn't say their blue lights are on, their siren is on. But they did flee after he stopped. You want $1 on that, or you just want,
Why don't we reset it for PCH?
you don't want to call the officer now?
No, we'll do it in the afternoon.
Okay, reset it for a probable cause hearing in the afternoon. So
Is he
I agree
out
with Ms. He's allowed to bond out, yes. I agree with Ms. Corey. There was only probable cause for the resisting without. But he's not even charged with that. Even if he's not charged with the resisting or without, I can still find PC for that. All right, we'll see you later, sir. Next, we have Louis De Leon. Page 9. Item up corrections. Good morning, Mr. De Leon. You were arrested for possession of a firearm, weapon, or ammunition by a convicted felon. I will appoint the public defender's office for you. There is probable cause for the charge. They found a gun in the center console and you're a convicted felon. Your bond is $7,500. Now, it's between the driver's seat. I'm sorry, that's where they found it. It was in plain view between the driver's seat to the right of the driver. I don't know why I thought it said center console. Anyway, it's a $7,500 bond. Have a nice day. Next is Louis Suarez.
Okay, friends, when I started the stream today, I had my eyes on 2 whole courtrooms because there was like nothing going on. And all of a sudden, I've got my eyes on 14. So there's a ton going on. Let's switch it up a little bit, though, and we'll head to a different part of Florida and see Wade Mercer for a few minutes.
Mr. Jones, I read the complaint. There is probable cause in the complaint, sir. But Mr. Jones, your criminal history is not horrible. You've got several priors, but the stuff you've got is older, in the 90s and prior to 2010, very little since then. Mr. Jones, the question I have is, do you have somewhere else to live on a temporary basis other than the home that the alleged victim lives in?
Yes, sir.
Where
my
would that
sister
be?
said I can expect, that'll be on 5148 Gold Lane, Mariana, Florida.
Okay, tell me it's not next door on the same property where the alleged victim lives, is it?
No, ma'am, it's on Blue Springs Highway, the first trailer park on Blue Springs Highway. Nowhere close.
Okay, let me see if the attorneys have any additional information, Mr. Jones. Mr. McDaniel, anything?
Yeah, just, that, Otto's been working at Sonny's, I think, for 10 plus years. And, as a master cook there, I think they call him, master chef. And we just asked the court to consider this release. It's been, I think, like you said before we put on there, he had some history that was all the way over. And on the facts of the case, Your Honor, it's not a, extremely bad case.
I think the allegation is he allegedly threw coffee in her face. His version is after she hit him. Her version is before she hit him. Thank you. So, Mr. Mitchell, what's the state's, any input from the state?
Let me just double check something right quick. Hold on. Nothing from the state, Your Honor.
Thank you. So, Mr. Jones, I'm going to let you pick between the bond and the conditional release based on your criminal history. And as Mr. McDaniel pointed out, based upon the allegations, if you'd like to post the bond, and some people prefer a bond, the bond I would set for this charge is $2,500 cash or surety. If you want to accept the conditional release, I'm glad to grant you the conditional release. You will have a condition of no contact with the alleged victim at all. Mr. Jones, that means no face-to-face contact, no electronic communication, no phone contact, and no third-party contact. You can't get someone else to go talk to her about the case. But you can pick whether you like to post the bond or like to accept the conditional release, or if you have a question, and if it's a question I can answer, I'll try. So you know what you prefer, sir?
The conditional release.
All right, I'm gonna grant you the conditional release. So what's gonna happen, Mr. Jones, is they're gonna bring you to the courthouse in just a few minutes after you get dressed. And the reason for that is because that's where the conditional release office is located. So when you get here, Mr. Jones, you'll meet with Mr. Goodson and Mr. Ham, one of our conditional release officers. They'll go over the release with you. They'll give you a chance to ask any questions. They'll give you all the rules in writing, and then you'll be free to leave. So, Mr. Jones, if you do contact somebody for transportation from the jail, you can tell them that you can be picked up at the courthouse in probably 30 to 45 minutes. Any questions?
No, sir.
All right, sir. Mr. Jones, the last thing we need to do is give you a court date. When you get here, I'll ask the probation office, to conditional release office, to give you a notice for your court date. When would that be, Jody? Today's the 21st. Let's go to the next one. September 29th, and you'll get a written notice for that day, Mr. Jones. Mr. Jones, you will
Yes,
not
sir.
get anything in the mail for the court date. That one they put in your hand will be the only notice you get for that court date of September 29th at 9 a.m. You have any questions?
Yes, sir. No, sir.
All right, sir. I wish you the best.
Yes, sir.
The next case we have is William White.
So while the next contestant comes up, judging from the stats I'm getting from YouTube, there are some new viewers out there this morning. So welcome. Feel free to introduce yourself in the chat. Very, very friendly community here. So I encourage you to participate.
Difference, but there's a typo on the jail sheet. It says resisting without violence. That's not correct. The charge that Mr. Wise is accused of in 2023 is resisting with violence. The second charge is fleeing and eluding. So, Mr. Wise, the failure to appear warrant has no bond. It's an old warrant. It's from over a year old. February of 24 is when this warrant was issued. So, Mr. Wise, you're going to be held with no bond until you can get to circuit court and try to get this case resolved. Mr. Wise, I'm going to ask Mr. McDaniel to notify your attorney that you're in jail with no bond. But you're going to have no bond until you see Judge Garcia. Mr. Wise, do you have any questions?
Yeah, I talked to your attorney about it.
Yeah.
No. Good luck.
Wish you the best. Mr. Wise. Next case is Kenneth Pringle.
Your Honor, Mr. Pringle requested to go back to his cell. We just asked the court to go ahead and set a bond.
Okay, anything other than that, Mr. McDaniel, anything I need to know about it?
No, Your Honor, nothing that I don't think I've let you know already.
Thank you. And he did send a text to both of us. Mr. Mitchell, anything from the state?
No, nothing from the state, Your Honor.
Mr. McDaniel almost set a standard bond for Mr. Pringle for the charge of resisting an officer without violence. There is probable cause for that charge. And 99% of the time I set a $2,500 bond for that charge. That's what I would do in this case. It's a $2,500 bond, cash or surety. Danielle Sellers. Ms. Sellers, good morning. You're here because you've been accused of one count of loitering and prowling. Ms. Sellers, there is probable cause for the charge, and I have looked at the complaint. I've also looked at your criminal history. I'm going to appoint the public defender's office to represent you, Ms. Sellers. I'm going to ask that you listen to Mr. McDaniel. We'll see if you have any questions in just a moment.
Your Honor, I've talked with Ms. Sellers. At this point in time, she's going to plea of no contest to the charge as listed. The understanding should be sentenced to 60 days in the county jail, 1 day jail credit. She has waived her right to a jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Thank you. Ms. Sellers, did you hear that agreement?
Yes, sir.
Any questions about that agreement?
No, sir. I remember all of it.
Is this the plea you would like to enter to resolve this misdemeanor?
I reckon, sir, that's the only offer I was given, you know what I'm saying? So,
Yeah, that's the only offer to resolve it today. Your other option is to ask for a bond. And I'll set you a bond if you wish. But if you want to resolve it today, that's the offer today.
that'd be fine.
Okay. So that you want to go ahead and plea and get it resolved. Is that what you want to do?
Yes, sir.
Ms. Sellers, I'm going to accept your plea of no contest to the charge of loitering and prowling. A judge you guilty sentence you to 60 days in Jackson County Jail. Give you credit for the day that you've already served down there. I've got imposed court costs and fines. They're set by state and county law at $370. Ms. Sellers, as you may know, ma'am, you very well may do less than that through the trustee program at the jail. I know they understand how it works. You may get some gain time. I'm not promising you that. I'm telling you that's possible, but that's between you and the jail. Ms. Sellers, there's no probation involved in this sentence. When you finish the sentence, you're through with this case. Do you have any questions?
Yes, no, sir.
All right,
Good luck,
wish you the
Jim.
best.
Your
Yes, sir.
Your Honor, I do want
Just a second,
to,
Ms. Sellers. Ms. Sellers, hang on, Mr. Mitchell wanted to add something. Mr. Mitchell.
I do just want to state something. She said that that would be the only thing that would be offered to her today. If she were to get a bond and be set for arraignment, my offer would be the same if it was that. So it's not the only choice she had. It's the same thing I would have made in this situation too. I just wanted to put that out there.
All right, thank you, Mr. Mitchell. All right, Ms. Sellers, wish you the best, ma'am.
Yes, sir. You too.
After Ms. Sellers, we have Jerome Davis, the third. Mr. Davis, good morning. Mr. Davis, you're here for first appearance. You were accused in adult court. Your case is now transferred to adult court of one count of burglary of a dwelling and one count of grand theft. When I read the file this morning, I thought that was an error because it looks like it was a church. A church is not a dwelling under Florida statutes unless it's a really unusual church. So Mr. Davis, I contacted the state and defense and asked if that was intentional. And I believe Mr. Mitchell has since amended the charge to fix that clerical error. Is that right, Mr. Mitchell?
Yes, Your Honor. I filed an amended information this morning for a third-degree felony of burglary of a structure or conveyance.
Thank you. So Mr. Davis, that's good for you because your charge went from a second-degree felony to a lower-degree crime, a third-degree felony. So as of this morning, what you're accused of is one count of burglary of a structure, still a felony, but it's a lower felony, and one count of grand theft. There is probable cause for both those charges. I'm going to set you a bond or consider other release options. And I'm going to listen to the attorneys. But before I do that, Mr. Mitchell, when I opened his file, there were multiple CJ cases, which is circuit juvenile cases. And there was at least one I opened that was a burglary case. So there were other cases that were pending or in the process of being resolved. One reason I'm asking that is those charges are not on his criminal history, probably because they're juvenile charges.
Yes.
So are you familiar with his criminal history?
I am familiar with his criminal history as it pertains to the juvenile cases. I believe he has 2 open juvenile cases right now. Since this will be handled in circuit court, I'll go ahead and dismiss his 2 juvenile cases.
Okay. All right. That I just want to, as a general rule, the state's not going to pump somebody up to adult court unless they have a juvenile history.
Yes.
So that was my question.
This was the case that this incident allegedly occurred 5 days prior to his 18th birthday. So that was one of the main reasons for that.
Okay. Thank you.
No
Mr.
longer
McDaniel.
juvenile. So, yeah, he's no longer a juvenile, so he is an adult.
But he was a juvenile when it occurred. That's why they had to do
Correct.
the direct filing, right?
Yes.
Okay.
Yes.
Mr. McDaniel, anything else before I set the bond?
No, Your Honor.
Mr. Mitchell, anything?
No, Your Honor.
Mr. Davis, I'm going to set you the normal bond I would set for these charges. The new charges, the burglary of a structure bond will be $5,000 cash or surety. The grand theft will be $5,000 cash or surety. Your total bond is $10,000. Cash or surety, I know that you probably don't know this, or you may not know this because they don't really have bonds in juvenile court. But your surety means you can go through a bondsman. It means you don't have to come up with all the money. So if yourself, your friends, or family go through a bondsman, that bondsman will charge you a certain amount to get you out of jail, and then they'll be vouching for the whole amount. And normally it's around 10%, but to see different bondsmen handle that different ways. So you get, after first appearance, you get to use the phone, Mr. Davis, to contact friends or family. If you post the bond, you'll be released. If you don't post the bond, then the public defender's office will see you at the jail in the near future. Mr. Davis, you do have a condition to have no contact with that church, period. So if you do post bond, you can't go back on that property. You can't go on that property at all. Mr. Davis, do you have any questions?
No, sir.
All right, sir. I wish you the best.
Yes, sir.
Brandy Merritt's.
Your Honor, Ms. Merritt refused first appearance this morning. She went back to her cell, so we just asked the court to set a bond.
All right. And Mr. Mitchell, any input on the bond?
Just very similar to Mr. Pringle, just the standard misdemeanor bond.
Thank you. Mr. McDaniel, any input on the bond? Anything else I need to be aware of?
No, Your Honor. Just what I've already sent to y'all, but yeah.
Okay, so I'm just going to set the normal bond I would set for those 2 charges. There is probable cause for both of them. I did read the complaint, and I have looked at her criminal history. I've been provided by the jail, and she's going to get a $2,500 bond on each case with a condition of no contact with the property she's allegedly trespassing at, which was a
Cottondale
Shell gas station in Cottondale. no contact with a Shell gas station in Cottondale, Florida. Mr. McDaniel, that's it as far as what I had on first appearance. Anything else I may have missed, sir?
Nothing else, Your Honor.
Mr. Mitchell?
No, Your Honor.
So there is one thing, and I forgot to do this yesterday. So in January, we had a little ceremony for our, and I forget the exact award that we gave, Mr. Goodson, you remember what it's called? Was it the Viewer of the Year? I think it was called Viewer of the Year. And that was awarded to Mr. Matthew Williams. Mr. Williams had a birthday yesterday, and Mr. Rooks asked me to tell Mr. Williams happy birthday, and I failed to do so. He's one of our most faithful first appearance viewers, and gives us a lot of feedback on that. So, Mr. Williams, wish you a happy birthday. This gentleman just came in the courtroom. Let me see what case he's on so I can tell him what he missed.
Davis's father.
My son,
Okay, Mr. Davis, we just got through with first appearances. Your son is Jerome. He was set a $5,000 bond on each count. He's got a total bond of $10,000. It's a cash or surety bond. That means he can go through a bondsman. He has a condition to have no contact with the church that he allegedly went to. So if you post bond for him, if someone posts bond for him, he'll be released until his court date. If you don't post bond, he'll be in jail until his court date.
It's a bondsman. Like, I don't know this.
Yeah, you can go through a bondsman if you wish, and the jail has a list of bondsmen that serve Jackson County at the jail. I don't have a list.
And his juvenile cases that you saw in front of me, I'm dismissing those, so he'll be handled in circuit court.
Thank you very much.
All right. Thank you for coming. So Corporal Drown, if you would let Mr. Davis know that his father did show up, he was just right after we got through with court. I'd like for him to know his father did show up.
Yes, sir.
Thank you, sir. Anything else? I need to talk to you about a scheduling issue, but we'll do that once we get off of Zoom. Ladies and gentlemen.
All right, friends, I've said this 1,000 times in the chat, but I'm going to say it out loud. I like this judge. I think Mercer is about as close as we're going to get to Fleischer as far as his caring about the people around him, challenging probable cause, things like that. I think he's a good guy. So Judge Boyd has been in the middle of a trial, but she does have a little bit of a morning docket before she gets started. So in our efforts to bring you 9 to 11% more Judge Boyd, let's go there.
530 State versus Cassandra Oberlinder. Can I have parties announced for the record?
Lauren Espinoza for the state.
For the defense?
Roberto Ambrosino.
And are you Cassandra Oberlinder?
Yes, ma'am.
All right, any objections to Miss Oberlinder appearing by Zoom?
None for the state, Your Honor.
And defense, I'm assuming you have no objection to your client appearing by Zoom?
No, Your Honor.
And Miss Oberlander, you do realize that if you wish to appear in person for this hearing, you can appear in person. Do you understand?
Yes, ma'am.
All right. So do you consent to having this hearing by Zoom?
Yes, ma'am.
All right. State, do you have any witnesses?
Yes, Your Honor. State Coach Aida Ramos.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yep.
All right, you can lower your hand. Make sure you keep your voice up for the court reporter to hear and for the persons on Zoom to hear. If you'll state your name for the record.
Aida Ramos.
All right, state, you may proceed.
Ms. Ramos, what is your occupation? I'm a realtor, property manager. Your property manager for which property? Simple Realty Services. Is Simple Realty Services renting to were they renting to a tenant by the name of Miss Oberlinder? No, that was her boyfriend. What is her occupation? Riley?
Okay, so guys, I'm so sorry. You are gonna have to speak up because I'm having trouble hearing. And the court reporter, I'm looking at her real time and she's having problems hearing. All right, so if you'll repeat your last question, please.
Yes, what was Miss Oberlinder's boyfriend's name?
Riley.
And was Riley a tenant with the property?
Yes, ma'am.
What property did he reside at?
1238 Cold Lake Drive.
Was there an incident involving Mr. Riley and the property, or I'm sorry, Miss Oberlinder and the property?
Yes, ma'am.
What incident was that?
She burglarized.
Was there damage? She broke in to which property again?
1238 Cold Lake Drive.
What damage was caused, if any?
Well, she broke in and she broke the door of the garage and went in, and I have the video where, because we had cameras inside, and she went in there and she also stole money. That I also have where her boyfriend Riley texted me, and she said that he
Objection, hearsay.
Sustained.
So you said she broke in through the garage, is that correct?
Yeah, the garage.
Did you have the garage fixed or replaced?
Yes, ma'am. I do have for the invoice here. I'm sorry.
Did you get an estimate done for that repair?
Yes, we did.
Through which company?
Alpine Property Group.
And how did that happen?
Well, after we made the report, you know, I did speak to the owner and he requested for us to.
Objection, hearsay.
All right, so just talk about what, may I ask a question? Any objection?
No.
Any
No, Judge.
objection?
No,
All right, so what damages are you alleging was caused by Miss Oberlander?
The broken of the door of the garage.
Okay,
and
the garage door, what else?
Camera.
And the camera.
Mhm.
What's the price to repair the garage door?
Like here, it was $850 for the door and the installation, and the security system was $650.
All right, so how much for the garage door?
$850.
$850. Does that include the price of the door
And
and the installation?
Correct.
And how much for the camera?
It was $650.
$650. State, any other questions? Defense, any questions?
Yes. Isn't it true that Riley, the actual tenant to the property, had a key to access the room where the camera was?
No, not that, only to his room. There was an attachment there where he actually lived. The door where she broke in, it was on the other side.
So in what manner are you saying that he broke the door or that she broke the door?
She broke in. Well, I don't know what she did because the camera was inside the garage because we had cameras inside the garage.
Isn't it true that she was given, or I'm sorry, that Riley was given a key by someone named Sergio that actually allowed him to have access, even though I guess there's some dispute over whether he was supposed to be entering into that property?
No, he only had the key for his area where he lived.
When did you repair the property after that?
The date here of the invoice is for June the 1st.
June the 1st of 2025?
2024.
Okay. This incident actually happened several months before that, isn't that correct?
Well, the incident happened. It happened, well, we repaired it after the break-in.
Right, but I mean, you allegedly let the house go unrepaired then for several months.
Well, this is where I have the invoice. I got it from the owner
Okay, why isn't the owner here today to testify?
because I'm the property manager.
Okay, so you didn't actually pay to have any of this fixed?
I didn't pay for it. It was the owner, the company, which is Simple Realty Services.
Okay, and so you don't know anything that wasn't secondhand information that was told to you by somebody else?
No, sir.
Okay, pass witness.
All right, any other questions?
I think we'll state your own.
Defense, any other questions?
No.
No, Your Honor.
All right, thank you. State, any other witnesses?
No.
All right, oh, I'm sorry, you may have a seat. Defense argument?
Judge, my client contends that there was a key to enter the property. Basically, this was a room that he was renting and he had access to the whole property, and that she, yes, did go into that particular room without consent, and she did damage the camera. So we do not contest that amount, but we do contest the amount that's being alleged with regard to entering the room that the camera was in. She basically states that she would have had access to it.
All right, state. So the defense is stating that they have no objections to the amount of the camera, which is $650. So the court is ordering the $650 restitution because the defense does not dispute that. Would you like to speak to the door for $850?
Your Honor, this offense is for the burglary of a building, which was through the garage. Because there was the camera on the interior, we did not see the exterior entry. However, despite them arguing this key was given by somebody else, this damage was caused. We would urge the court to order this restitution because the damage was done to the garage.
All right. So this is what the court is going to do. What is the owner's name of the property?
Either Ramos.
All right. The court is, in this case, the court is ordering that restitution be paid in the amount of $1,500 for the price of the garage door and the price of the camera. All right. Is there anything else?
Judge, can I get the name of the, or that's being paid to?
State, if you'll give her the name of the property owner, please. All right. Thank you, counsel.
Thank you, Your Honor.
All right, I'll keep an eye on her as she works through the docket. Let's stay in Texas, but we'll go over to Judge Stevens. Or we won't, because just as I go there, he deletes his stream. He has a habit of doing that lately. Let's go back to Miami-Dade for a few minutes.
As for counts 2 and 4, there's nothing indicating any prostitution in the case.
Su señoría, no, le pido que no encuentre causa probable para cargo número 2 y 4. No hay ninguna indicación de prostitución.
Looks like the female was wearing compression garments.
Luce como que si la mujer tenía vestimentos de compresión.
Or her torso down to her ankles, and her arms were also covered.
Desde el torso hasta los tobillos y sus brazos estaban también cubiertos.
And she was recently recovering from cosmetic surgery.
Estaba recientemente recuperándose de intervención cosmética.
Doesn't mean she couldn't have sex.
There's no
Eso no quiere decir que no puede tener sexo.
There's no mention of sex on the arrest form.
No hay ninguna mención de sexo en el informe de arresto.
If you don't offer money for sex, it's not prostitution.
Si uno no ofrece dinero por sexo, no es prostitución.
They agreed for a date with she had agreed for a date with the undercover, and he dropped
For a massage, Judge.
Well,
Estuvo de acuerdo a la cita, bueno, su señoría, para un masaje.
Full service.
Full service.
Es un servicio completo entonces.
Well, until you define what full service is, if it's unclear, which is
Hasta que usted define que es un servicio completo.
Listen, even this old lady knows what that is.
Would be all kinds, but if it's not stated, Judge, then it sounds like a.
I mean, I could have the detective testify.
You don't wear full compression garments for a sexual encounter. It
Uno
just
no
is not
usa
a turn on,
vestimenta de
Judge. I
compresión
think we can
completa
all-
para un encuentro sexual.
We can agree to that on an encounter with a male.
Actually, Miss
fully
F.
covered in
I
compression
mean,
garments.
okay. I'm sorry to the interpreter too. I don't know if she wants it.
Renee, you want to
Got
check
it.
in?
If not, Detective Mayer, what does full service mean?
Señor, Detective Mayer, ¿a qué se refieren con servicio completo?
In my training experience, it means a full sexual encounter.
En mi capacitación y experiencia es un encuentro sexual completo.
And those compression garments, can they come off?
Yes,
¿Y ese
ma'am.
vestimento de compresión se puede quitar? What was your answer, detective?
Yes, ma'am.
Sí.
Have you ever encountered a case where a woman offering sexual services was fully dressed in compression garments after completing a cosmetic surgery?
Judge, I think we're going a little too far with this one.
You're gonna have Miss Corey. There's probable cause. Okay.
Hay motivo
There's
fundado
nothing
para el
indicating any
arresto.
exchange, Judge, at all for a sexual encounter. Because the officer may have had that in her background with other cases, there's nothing indicating on this incident that this was meant for a sexual encounter.
It is. Miss
Señoría,
probable
solamente porque
cause.
el
There's
detective haya tenido eso en su experiencia no quiere decir que este fue un encuentro. La jueza dictamina que sí hay suficientes indicios de criminalidad.
Judge, Mr. Gomez Jimenez would have to be aware and have that knowledge and intent According to the arrest form, he indicated to the officer that she was coming to the location to give a massage, which would make more sense if you're going to be fully dressed in compression garments after recovering from a lot of plastic surgery, Judge.
Señorías, se le indicó al detective que no estaba al tanto ni con la intención y que venía para un masaje y que se daría más sentido si uno está vestido en vestimenta de compresión.
Interestingly enough, they found the box of condoms in the passenger side door where she got out of the car.
Interesantemente, suficientemente interesante que encontraron una caja de preservativos sexuales en el lado del pasajero.
What was the battery? I forgot. He pushed off the officer's chest and ran. So count one, there's probable cause for battery on a law enforcement officer. That's a $5,000 bond.
En cuanto al cargo número 1 de agresión contra un agente del orden público,
Count two.
Causa probable $5,000 de fianza.
Count 2, deriving support from proceeds of prostitution. State, what do you want on this? Like 1,000,
El cargo
1,500?
número 2, derivar ganancias de la prostitución. ¿Qué es lo que desean?
What'd you say?
It's fine, 1,500.
$1,500, count 2. That's a second degree felony.
$500.
Count 3, resisting an officer without violence is $500.
$500 por resistir al policía sin violencia.
And count 4, directing another to a place of prostitution is $150.
$150 por dirigir a otra persona a un lugar de prostitución.
And Judge, just for the record, probable cause on counts 2 and 4 is over defense objection.
So
Es
noted.
solamente para que conste en el acta, causa probable para el cargo número 2 y 4 son sobre la objeción de la defensa.
All right, also he has an immigration hold. Thank you, detective, for coming in.
Una orden de detención para inmigración.
All right, Mr. Alexander, I see you're here. Do you have the victim online on Zoom?
Yes, good morning, Your Honor, I do.
Okay, so can Ms. Rojas raise her hand on Zoom so we can promote her, please? I need Randy Dodore, please. Some cases here are interesting, more interesting than others. Okay.
Yeah, my case doesn't seem that nearly that interesting.
Yeah, most of them are not. Sometimes we get something's interesting. Anyway, Miss Leslie, you need to raise your accept a promotion as a panelist. Put on your video and unmute. Hi, Mr. Dodore. I believe the alleged victim is here.
Is my hand raised?
Yeah, but you got to put on your camera.
Oh, hold on.
I don't need to put it. I can lower your hand. Just put on your camera. There you go. Please raise your right hand. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
I do.
Thank you. Put your hand down. Please tell me your name.
Leslie Rojas?
Ma'am, are you afraid of Mr. Randy Dodore?
No.
You want the court to order him to stay away from you?
No.
Has anybody forced you or threatened you to come to court today to make this statement?
No.
Thank you. Miss Seth, do you have any questions?
No, Judge.
Mr. Alexander, any questions?
No, Your Honor.
Do you two live together now?
Yes.
Okay, thank you. And you have a child since this incident?
Yes.
Thank you. All right, Mr. Dodore, I am entering a modified stay away order from the alleged victim, Leslie Rojas. You are allowed to have contact with the alleged victim. You are prohibited from being physically threatening or violent towards her in any manner whatsoever. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand this stay away order, sir? Do you understand the modified stay away order? Only friendly, nonviolent contact is permitted. I can't hear you.
Yes.
Okay.
Your Honor, regarding the firearms, he is on probation, so he would not have any firearms to surrender at this time. The probation predates this.
Oh, okay. It happened in 2023. What do you want me to do? You want me to order him to pretrial? You want to set a bond? What do you want?
Just low bond, Your Honor.
Yeah, all right, count 1 aggravated assault with a firearm will be $1,500. Count 2, unlawful discharge of a firearm on the property. I'll set that at $150. Count 3, criminal mischief, $150. So the
Thank you very
total
much.
bond is $1,800. Have a good day. Thank you.
Thank you very much. We have a
Thank you
bondsman
for
ready.
coming in. Thank you.
Thank you so much. Take care.
Bond, Your Honor.
1,500, 150, and 150.
I'm gonna reach out to the bondsman.
Straight bond. You have a bondsman.
Thank you. Take care. Thank you,
Correction,
Judge.
you know, it's no hold. Do I have to say that again?
The probation was Broward.
Oh, okay. It's Broward probation. Thank you.
Thank you very much.
We do have a private attorney for a female.
Okay, I'm trying to get to my females.
Okay.
All right, well, she tries to get to her females. This has been an interesting day so far. I hope you're all having fun. We're going to go back to Judge Boyd, but before we do, I would like to discuss the sponsor for today's program, and that is Aura. You guys know them. You guys love them. If you're not already using them, you should be. I'm going to read you a name of companies. AIS, Brooksim, Buxton, DeepSync, Demist, Fetcher, IQVIA, LeadSpace, Lime Leads, LiveRamp, Pop Acta, Posty, BDO, Reclaim, spelled with a K, of all things, Blackbaud, Samba, Media Walla. The list goes on and on and on. And I read you this because these are all companies that I'm looking at live on my Aura dashboard that had my information, and Aura has removed it. Aura is in the business of removing your data online, keeping you safe online, and they are the best at it. They reached out to this channel to partner, and before I would say yes, I said prove it. So they got me in with Aura, they got me using it, and within 24 hours, I saw all the places where my data was, and I saw all the things they could do for me. And it goes just beyond data removal. There's transaction monitoring, there's spam and junk email removal. They've got a really good antivirus. They've got a very good VPN. The VPN they partner with is actually one that I've used for almost a decade now. It's incredibly good. Spam call protection, which is another thing I've been benefiting from. Parental controls, a password manager, you name it, the list goes on and on. This is a service that makes sense for the viewers of this channel because we watch enough court to know that there are bad actors out there, and your data is out there for people to act badly with. So get that data removed. And here's a good deal. Aura.com/TCF. You get 14 days for free to try it out. So give it a try. If it's not for you, life goes on, but I'm pretty sure it will be for you. You will be amazed at what they can do. 2 weeks is more than enough time for them to show it to you. You'll figure it out within the first 24 hours like I did most likely. But give it a go. There's no reason not to. If you're on the fence about it, get off the fence. Because again, there's nothing to lose. Aura.com/TCF. You can use the QR code on the screen. There's a link down in the description. Give them a try. Not only help yourself, but support the people that support the channel. As promised, let's go back to Judge Boyd.
It's going pretty well. Just administratively, the reason I got into the program was, I guess, for one, was a reset. But the first thing is that Mr. Soriano is now indicted as a first-degree felon.
Yes.
Additionally, there's an additional case that's a first-degree. I'm not on the first-degree list. Ron Ross was either appointed by the court or by MAC to handle the additional first-degree. The case that I was originally appointed to, again, is a third degree. It's now been indicted as a first degree. I'm not on that list. I wanted to bring that to the court's attention to see how she wanted to proceed.
All right, Ms. Ferguson. I guess since Ron Ross, he should be here today, right?
Which case is he on?
Soriano on page 10 on all cases. Adam, where have you been? Where have you been? Enjoying life?
I do have a flight today to about.
Oh, where are you heading?
Out of state.
Okay, well, enjoy. I hope it's for something that's fun and not work.
I'll send you a text.
Okay.
So that it's not aired everywhere.
Okay.
Bob listed on the PF case. And then the two indicted cases have passed.
All right. So Norma, if you can put Ross on all of the cases, please. All right. So we'll put him on all of the cases. And what we'll do is we'll reset your case for 30 days. That'll give him a chance to look at these charges as well, okay?
Okay, Judge.
All right, do you have any questions about anything?
I am aware that I have court on the 27th still. Am I still going to appear for that one or?
That
Is
should
there-
be the PF case.
All right, that PF case is not, Norma, is that PF case going to be set here? Yeah, so that's with Judge Nahara, because that's where they send the PF cases. But I'll set you here in 30 days and maybe they'll just move it here. What date, Ms. Ferguson? All right, so we'll be back on September 22nd in this court. And then your attorney, Ross, he'll get notice that he's been placed on these cases as well. All right. You're welcome. Counsel, is there anything else?
I'll submit my voucher. Thank you, Your Honor.
All right, thank you. All right, have a good day. Excuse? Yes, thank you.
Okie dokie, let's go back to Judge Glazer.
I'll
definitely tell her you said hello,
Well,
Judge.
I'd like to see her. Say hello to her old
I will.
acquaintance from
Thank
years
you,
ago.
Judge.
Bye. Thank you.
Yana, can we go back to the first female? Miss-
I'll go wherever you want me to go. I'd like to go take a break and exercise, but I can't. You know, there's mullet are still waiting to say hello to me. There's whole little babies there yesterday. Yeah. I like to walk to the river at lunchtime and sit and look at the water and the fish. This is Desiree Gonzalez on page 1, right? We're starting page 1 now at 10:59.
Yana, for the first female, five-timer, on the case number that ends in 61, F2518061, you gave a pretrial. Was that the alternate 2500 or 5?
Yes. No, that was 2,500. The other case was 7,500.
Thank you.
The arson was 7,500. Make sure it's right, Ash. All right. Good morning, Miss Gonzalez. Do you speak English?
Yes, ma'am.
All right, you were arrested for sale of cocaine and prohibited drinking in public. I will appoint the public defender's office for you.
Judge, pretrial's good and I think possession.
She's sitting under a tree drinking a beatbox alcohol beverage in plain view of pedestrians, and the police see her. They go over. What's going on? They see she has 5 suspected crack rocks in her pants, in her underwear, groin area. So there's probable cause. Pretrial services, alternate bond. What? It's not sell. It's
No,
not
possession. Miss Corey wants tap.
Tap.
tap. Okay, so remember, we will only want to give pretrial when somebody has an address that pretrial can verify. Otherwise, it's a tap program. Tap alternate bond. Count 1 is $2,500. Count 2, the drinking in public will be $1. Have a nice day. Oh, you need a date?
For possession only. Yes.
Right. A date, you need a date to come to court. So today's is September 22nd. The arraignment date is 9/22 at 9 a.m. Courtroom 7-4.
I think, okay, you're right. I think the 23 is Rosh Hashanah, so 22 is good.
Oh, yeah. Gotta be a good person and make a brisket. Okay.
Judge, we don't have to change the dates with the new arraignment stuff.
They didn't tell me anything. I'll ask Judge
maybe
Jean. I
so.
don't know. They don't come anyway, so it doesn't matter if it's 30 days or 60, because I hear from the judges that people don't even show
hopefully
up
she will.
anyway. Okay. Well, give me a second. Now I gotta go fast. Wait. Excuse me. Next case we have is Patricia Laudagan. Page 1. Good morning, ma'am. You were arrested for aggravated battery. I will appoint the public defender's office for you. This happened at a church.
Right, the weapon is a can of peaches.
And I would ask if we can reset her for the afternoon for possible hospitalization.
Yes, reset. There's probable cause for aggravated battery. She struck the victim in the head while he was sitting by a computer with a can of peaches. Okay, you are ordered to stay away from Adrian Jones, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties, and you must stay at least 500 feet away from the victim's home, school, and place of employment at all times. Do you want me to order her to stay away from the church too, or no? Stay away from the Fulford United Methodist Church as well at 1900 Northeast 164th Street in North Miami Beach, Florida. Do you understand, ma'am?
Yes.
Okay.
What about if I'm walking by because that's on the sidewalk?
You can try and walk on the other side of the street, so there's no
Okay.
problems, okay? Also, is it okay, you wanna go to the hospital? I can reset your case in the afternoon to see if you have hospital benefits. Is that good?
Okay.
All right, reset for hospital in the PM. Card only is fine. So on the weekends, if you get hospital cases, you just reset it to Monday. Or if it's a holiday weekend, Tuesday, so that Ms. Corey can address any hospital placement. Renee, can you finish filling in the address of the church, please? Sir? Thanks.
Michael, you made me LOL and LMAO. I would totally start singing that song if it wouldn't get the stream claimed. Oh, good Lord. Too much food violence out there right now. It's been a theme this week. We had this one guy, it was in a different video, where he attacked his mother with a spear over a dispute on butter. What is going on in the world? Anyways, back to Judge.
She was charged with accessory.
Oh, I remember the
after
e-bike.
fact. And then she goes back to the house and leaves a note for the victim, asking the victim not to press charges because of potential immigration consequences.
There's probable cause for tampering with the victim, so you are ordered, oh, you don't have this.
I didn't see it.
It was in the other case, but it's okay. Bye, guys. Thanks for visiting. Good luck. You're all gonna need it. Be good lawyers. Okay, next, there's probable cause. What do you want me to set the bond at? 2,500, I
That's
guess?
fine.
$2,500 bond. You'll see your judge tomorrow for your hold, ma'am. Good luck to you. Next we have is Evangeline Pierre, page 2. You can throw it out. She had the name. Well, let me see that back. I got it. No, not this, the other one. She qualifies for pretrial? No, the eighth one.
He's got.
Ma'am, you were arrested for possession of MDMA, a controlled substance. I will appoint the public defender's office for you.
She's got priors out of county. There was a probation violation from May of this year out of Broward. There's priors out of.
Not violent. It's a half a gram of MDMA. Listen, I'll give you pretrial. Make sure to keep all of your future court dates. Pretrial services alternate bond, $2,500. Have a nice day.
So overstates objection based upon criminal history.
Selena Solis is for the hospital. I think you sent me an order. I'll sign it after work. Actually, you know what? By the time we finish, it may be noon. You may want to bring me the computer, if you don't mind. So Miss Solis is card only, right? Or no?
Miss Solis is here, Judge. English.
Oh, hi, Miss Solis. I'm told you had hospital benefits. Is that right, Miss Corey?
Yes, Judge, I sent an order to your honor last night.
Okay, so it's custody release to Southern Winds Hospital, alternate bonds. I don't know. What do you want? 5,000?
Yesterday, 5,000 count one, 2,500 count two.
Oh, right. 5,000 count one, $2,500 count two. Make sure to keep, after the hospital, you'll see a judge, and that judge will determine if you'd still need to post a bond or if you can be released another way. Good luck to you, ma'am. Next we have is Laura Armstrong. Bond out. Ashley Morales, page 2. Man, we're not gonna finish here till 1 again today. Thank you.
Ms. Morales is present. She speaks English.
Good morning, ma'am. You were arrested for retail theft. I will appoint the public defender's office for you. It's
Ms. Corey, you want to waive the issue for pretrial?
It should be, well, there's two cases.
Well, she's pulled out of Bath and Body Works and Sephora. The Bath and Body Works was $175. The Sephora, there's no value listed.
Well, she's also got a pending misdemeanor, so I'm assuming the Sephora is the petty theft and that this is the retail theft, but it's really only $175, so it should be a first-degree misdemeanor.
Okay.
Check it, but I think maybe you're right. Let me see.
Yeah. Ma'am, you are ordered to stay away from the Sephora store at 1675.
Bath and Body Works, Judge.
Bath and Body Works?
Yeah, I did it wrong.
Oh, okay.
Well, she should also stay away from the Sephora. That's the victim in the misdemeanor case.
So I'm doing this one. Stay away from the Bath and Body Works store. Is it the same location?
It's at Town and Country, that mall. It's,
I don't know, 1675 West 49th Street in
yes,
Hialeah?
that's Bath and Body Works, yep.
Okay, so stay away from that location of the Bath and Body Works. You're not allowed to go there. Is she, I don't have, see her priors.
There's
Is,
no criminal
Is
history.
the bondsman here?
oh, she's a bondsman. So her bond, it's only probable cause for petty theft of first degree misdemeanor. That bond is $500.
Just you're right, 500.
No, she has a bondsman here. It's petty theft and first degree misdemeanor. You want me to say, is it easier if I do 1,000? Same thing.
So on the misdemeanor, are you appointing our office judge?
I'm not, the misdemeanor's not before me,
No, I know. What,
only on this.
why were you
one.
saying 1,000, Judge?
No, I said I could set this bond at 1,000 or at 500. Sometimes it's easier with the bondsman doing 1,000. That's how it used to be, but I'll leave it at 500. They charge whatever they charge. Okay?
Thank you. And
All right.
questions, is she gonna go soon on her misdemeanor?
Yes,
Thank you. Today?
today,
After-
yes.
Thank you.
Next we have is Mariladies Gomez, page 3. Bond out. That's good. She had 2 cases. Next is Isoleaf Gutierrez Madriaga, bond out.
Yes.
Oh, the assisted living facility ones. Okay. And the insurance. All right.
We got ambulance chasers today and ALFs.
That was a busy day here. You never know what you're gonna get. All right, so also you said, is Chloe Castellanos here or is she a bond out?
This is an added charge. She was on calendar yesterday.
Oh, hello, ma'am. Good morning. So in this case, you were arrested for grand theft, a 3rd-degree felony, organized fraud, scheme to defraud, conspiracy for scheme to defraud a financial institution, and fraudulent use of personal identification. This is from May 23rd of this year. I will appoint the public defender's office for you. Oh, she's also charged with unlawful use of a communications device too.
That I don't see. I don't know why they're charging her with that.
2 unauthorized withdrawals from the victim's Truist account in South Beach on 5th Street.
Maybe it's the messages on the cell phone with the personal identification.
I don't know. Ma'am, you're
Ms. Castellanos does not have funds for a bond. She's asking if you would consider house arrest for all her cases. She tried to contact a bondsman for the ones yesterday. Was it yesterday? She was here.
Yes, I don't have any money and neither does my family. I don't have family in Miami and my kids are here. They live with me just so I can be home with my kids.
You know, I cannot do that, ma'am. There are so many victims who were defrauded, who have the aggravation of having to now try and recoup their money and figure out why their ID was stolen. So I don't think house arrest is appropriate. And I'm setting a monetary bond. I agree with Ms. Corey. I don't see probable cause for unlawful use of a communications device. You're gonna have to go see the division judge, Judge James, if you're seeking any type of house arrest, because I'm not giving it to you. Count 1, there's probable cause for grand theft here. It was $6,000, 2 withdrawals, $6,000 and another one for $5,000. She went back 2 separate times to withdraw this money back in May. Count 1 grand theft is $2,500 bond. Count 2 organized fraud is $2,500. Count 3 organized scheme to defraud. I don't mind, or conspiracy for organized scheme to defraud. I'll set that at $1,000. Count 4. Fraudulent use of personal identification. I think that should be a 3rd-degree felony. It's charged as a 2nd. So I'll set that bond at $2,500. Count 5, unlawful use of the communications device. I do not see probable cause. Do you
On
want?
count 4, I think it's a secondary felony because it's over $5,000.
Really?
Yeah.
Well, the other ones were. I don't think they were 2nd-degree felonies, were they? When we saw her yesterday, yeah, maybe they were. That's all right. I can lower it to that. She's gonna have, I have a feeling there may be more. I also imposed a NEBI requirement, didn't I?
Requesting an
Yeah.
ambulance.
And count 5, you want $1 and a release outright.
$1 fine, Judge.
$1 for count 5. That's plus a NEBI requirement. You have to show the money used to post your bond is from a legitimate source of funds. Good day, ma'am.
Okay, so we're going to switch it up and go to Judge Anna Garcia, still in Florida. But before we go there, Favor.
Don Marcellano.
Oh, shush up. Favor, we have our panel discussion tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific, where we hash out various topics, but we haven't decided yet what we want to talk about tonight. So let me know in the chat, is there a specific courtroom-based topic or legal topic that you would like us to discuss? If you have ideas, put them in the chat and we will consider them. All right, let's, as promised, let's go to Judge Anna Garcia.
Mr. Russell, good morning.
Yes, ma'am.
Mr. Russell, we're hearing your case number 24 CF 600. Are you able to hear me okay?
Yes, ma'am.
Excellent. Mr. Russell, listen carefully to Mr. Derek Blunt. He has something to announce to the court, and I want to make sure this is what you want to do.
Good morning, Mr.
Yes,
Russell. I'm Derek
One
Blunt.
of my gentlemen in the back, please assist the person who would like, yeah, thank you.
Ms. Hussey's mother.
Okay, perfect. Thank you. All right.
Your Honor, Mr. Russell, I'm Derek Blunt. I'm with the Public Defender's Office. I work with Mr. Green. You were brought to our attention. I work with the drug court, and we discussed your case yesterday. We, as a team, are looking very positively and welcome you to drug court. There's a lot of things we need to check on, and based on the situation of the violation, even though it is, and it's kind of not quite our policy going forward as to the individuals we take with those type of violations, we're still looking at accepting you in the drug court. However, it will be the September 17th drug court date. Are you still wanting to proceed into drug court? If not, then Mr. Green can look at other offers and negotiate with the state. If you want drug court, you will likely come in and enter into drug court on September 17th.
Yes.
Your Honor, we would ask that he be set for the September 17th drug court date, and he will enter into that subject to the court's approval as long as everything checks out. So
Sure.
I think he'll be a good candidate.
All right. We all did too, Mr. Russell. And so we hope all the questions that we have can be answered to our satisfaction. And if so, then we'll see you September the 17th at 9 a.m. Okay.
Yes, ma'am.
All right.
Talking
Thank you.
private, you had one individual that went to bat for you, like extremely. So I'm going to tell him about that.
All right.
Thank you, Your Honor.
Thank you, Mr. Blunt.
I'll give you some more.
He'll take more.
Thank you.
All right, Mr. Green, call your cases as you wish, or does the jail have a preference? You guys go with, all right, however you guys want is fine.
Timothy Bailey, he's scheduled for trial on September the 2nd. So that's right, we changed it.
Yeah, it's September 4th. Timothy Wayne Bailey, please come on up. We're here in case number 23 CF 565. Mr. Bailey, good morning. Are you able to hear me and see me?
Yes, ma'am.
All right.
Good morning.
Your attorney has just indicated to me that there is no resolution between you and the state, and that he would like to set your case for an evidentiary hearing on September the 4th. Is that the agreement, Mr. Green?
Yes, Your Honor.
Any objection from the state? All right, September the 4th, evidentiary at 1:30. So, Mr. Bailey, we'll see you then at the latest, okay?
Okay, thank you.
Thank you, sir. Next case?
Next case is State of Florida versus James Russell Coleman, 24-102 CF.
Mr. Coleman, good morning. Are you able to hear me okay?
Yes, ma'am.
Excellent. Mr. Coleman, please listen carefully to your attorney, Mr. Green.
Your Honor, he's been screened for a drug court for inpatient drug treatment, rather. And we'd like to bring him back on 9/4. If we don't resolve with him, he'll be set for trial for the 10/9.
What says the state? All right, Mr. Coleman, your attorney has asked that I bring you back on September the 4th at 9 a.m. You are being screened for inpatient drug treatment.
Yes, ma'am.
Thank you, sir. We'll see you then.
This case, State of Florida versus Sterling Crumpler, case numbers 22-155, 21-699, 21-439.
Mr. Crumpler, good morning.
Morning.
Are you able to hear me okay?
Yes, ma'am.
All right, Mr. Crumpler, please listen carefully to your attorney.
Your Honor, it's my understanding the state's going to dismiss the affidavit.
What says the state? Oh, I'm sorry. I see, yes, Mr. Gill has indicated that the state will dismiss the affidavit. Give me some intel. Do you have any intel? Says that Mr. Gill spoke with Mr. Mitchell and that they were dismissing it based on the misdemeanor criminal mischief affidavit. All right, fair enough. Mr. Crumpler, the state has asked and agreed to dismiss the violation affidavit. If this is the only reason that you are in custody for an alleged violation of state probation, then you shall be released from that detention. If you are in custody for another reason, then you'll remain until you resolve that matter. Do you have any questions for me?
No, ma'am.
All right, thank you very much. Mr. Green?
This case, State of Florida versus Angela Daniel, case number 24257 CL.
Ms. Daniel, good morning.
Good morning.
Ms. Daniel, please listen. Are you able to hear me okay?
Yes, ma'am.
Excellent. Please listen carefully to your attorney, Mr. Green.
On behalf of Ms. Daniel, she'd move to withdraw her for a plea of not guilty and enter a plea of no contest to violating probation. Agreement with the state subject to the court's approval. This court revoke her probation adjudicator guilty, sentence her to a year and a day in Florida Department of Corrections with credit for 124 days to be $500 added to her monetary obligations, all of which would be reduced to a civil judgment.
Oh, she's on the jail screen. I'm sorry. Is this the agreement with the state? Yes, Your Honor. Ms. Daniel, please raise your right hand. Ma'am, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Tell me your full name for the record.
Angela Daniel.
Did you hear what your attorney just said?
Yes, ma'am.
Is that what you wish to do?
Yes, ma'am.
Has anyone promised you anything other than what he just said to get you to do this?
No, ma'am.
Is anyone threatening you?
No, ma'am.
Ms. Daniel, I have in front of me a one-page admission form. This is the document. I'm showing it to you on my screen right now. Did you sign that document right there?
Yes, ma'am.
Did you have enough time to review this document before you signed it?
Yes, ma'am.
Have you had enough time to talk to Mr. Green?
Yes, ma'am.
Are you satisfied with his advice and with his counsel?
Yes, ma'am.
Do you understand, Ms. Daniel, that by entering into this plea today, you are giving up your right to go to a VOP evidentiary hearing where the state has to prove that you violated the terms of your supervision?
Yes, ma'am.
Do you understand that you're giving up your right to present any defenses that you may have to the alleged violation?
Yes, ma'am.
And do you understand that you're giving up your right to appeal anything except an illegal sentence by this court?
Yes, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
All right, Ms. Daniel, I find that your admission is knowingly and voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of said admission. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Mr. Green, I may not have asked you, is there a stipulated factual basis for
Yes, Your
purposes
Honor,
of
I'm
the
sorry.
admission? No, that's okay. Ms. Daniel, in Jackson County case number 24 CF 257, I accept your admission of the violation of supervision. I'm going to revoke the terms of your supervision, adjudicate you to be guilty of the underlying offenses, sentence you to serve a year and a day in a State Department of Corrections with credit for 124 days. You've already served towards that sentence. I order that you pay an additional $500 court cost, fines, and fees. However, I will reduce all monetary obligations to a civil judgment. Ms. Daniel, do you want me to recommend that you be housed somewhere in particular?
Gaston.
I will so recommend. Ms. Daniel, do you have any questions for me about the sentence that I have just imposed?
No, ma'am.
Is there anything further from the state or from the defense?
No, Your Honor.
All right, Ms. Daniel, I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose, okay? Yes, ma'am. Ms. Daniel, good luck to you.
Thank you.
Mr. Green, give me just 1 second. Amanda.
All right, let's go back to Judge Boyd.
All right, the court is calling 2025 CR 006931, State versus Amber Marino. Can I have parties announce?
Lauren Espinoza for the state.
And are you Miss Marino?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Ms. Marino, did you review the application for deferred adjudication with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, are you waiving the reading of the indictment?
I am, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Marino, did you review court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Moreno, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's to be a $1,000 fine probated. The state is recommending deferred adjudication. There's to be restitution to the complainant in the amount of $1,764.08. Did you understand that to be the plea?
Yes.
Defense?
Yes.
State?
Yes, Your Honor. Can it just be noted that this restitution has to be split amongst 3 co-defendants? So I guess joint and several liability for that restitution amount?
All right. So here's the thing with that, and I think your attorney probably explained it to you. If there are other people who are part of this, all of you owe that amount.
Yeah.
If for some reason, if it's involving let's say it's involving a total of 3 people, I don't know how many people that are alleged. If 2 people decide they're not paying it, then you have to pay the entire amount. Do you understand?
Yes.
So I know that sometimes when people enter pleas, in their mind, they'll say, oh, let me divide this restitution amount among 3 people, and then I only owe that amount. Do you understand?
Mhm.
Now, if the other parties are paying their sum, the person that's owed this money, they're not going to be able to get $1,764.08 from everyone. It's just, that's the total amount. Do you understand?
Yes.
All right. Does that clear everything up, State?
Yes.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yeah.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, state offers what has been marked as State's Exhibit 1.
No objections, Your Honor.
All right, did you, oh, and state you may be excused. You're welcome. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. Right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
Yeah, we spent a lot of time yesterday, going over everything, and she's agreed to accept responsibility. At time to plead guilty, and I suggested to her to plead guilty, because she is guilty, rather than try to hide behind a no contest plea. So that really demonstrates an acceptance of responsibility. A situation where she was just overwhelmed by what was going on in her life, and something snapped yesterday. I really characterize this as average behavior. She's never been in trouble before, 22 years old. So we've asked the court to give her a chance on deferred and follow the plea agreement.
Okay, you say she's 22? All right. So let me ask you, who is Roman Villarreal to you?
That's my boyfriend.
All right. And your relationship to Valerie Marino?
That's my sister.
All right. And how old is your child?
She's 3.
3? All right. So let me explain something. And this is what I would always tell my clients who are on the CPS side, right? When people have a child together, that's the person you chose to have a child with, right? It's very important that you're able to co-parent, because even though you're no longer with that father and maybe you've moved on with someone else, your child still needs to see what healthy relationships are. And I know your attorney is saying this is out of character, but if you can just internalize and think about how your child was feeling with all these adults, these grown people just screaming. And this is what I've learned. And you've done family violence cases. This is what I'm sure your attorney has probably told you. If he hasn't, I'm going to tell you. During child exchanges, unless this is like a Hallmark movie, don't bring your significant other with you for a child exchange. I have never seen that work out well. So by the same token, if the father of your child is coming to pick up his child, he shouldn't be bringing his girlfriend with him. And if you're going to pick up your child, you shouldn't be bringing your boyfriend or new husband or whoever it is with you, because tensions just rise. And if there's an issue where people are concerned about their safety during custody exchanges, that's when you say we're going to meet at a substation or meet at the police. You understand?
Yes.
But from reading everything, I see that there were issues going on, and maybe the child needed help and all of these other health issues going on. So the $1,000, how much are you able to pay per month towards that? And here's the thing, give me a reasonable number, because sometimes people think I want to hear, oh, I'll be able to have $1,000 in 20 days. If that's not you, that's not you. It's just that I'm going to be placing you on deferred adjudication. I'm going to grant your application, but you're going to need to be able to let the state know and I'm sorry, the probation officer know how much reasonably you can pay a month, because this has to be paid off. And since one person is your sister, the other one is your boyfriend, you know, usually your mother will say, hey, you better help your sister pay this off. So reasonably, what do you think you can pay per month towards this amount?
I can do 100.
Okay. All right. And was CPS involved at all?
No, Judge.
All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. Are you employed?
No.
All right. So how are you supporting yourself?
Well, I'm getting child support, and
Mhm.
my boyfriend would be the one to financially.
Okay. Here's the thing that, you know, as a side note, you never know if a boyfriend is going to be around for the long haul. You never know if somebody has a girlfriend, if they're going to be around for the long haul. So you need to be able to say, because you have a child, you need to be able to say, you know what? If he were to leave, how am I going to support myself? Will I be able to provide a roof over the head for me and my child? You understand?
Yeah.
So you have to calculate that. All right. In this court, I require that people have employment. All right. So there's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be restitution of $1,764.08 to the complainant. Are you all able to do child exchanges at a location different from this location?
She'll have to answer that, Judge. I don't know how she's doing that now.
We're doing exchanges at the police station on Sassamona.
Okay. All right. So for now, you can't have contact with that specific address. State and the complainants don't want her back at the address, correct? All right. So you can't have any contact at that address. If there's an emergency that comes up with your child and it's at that address, then you'll probably have to call the police or somebody for a welfare check. Your attorney will let you know what to do in that situation. Okay.
Okay.
So there's to be no contact with the location. And at some point, if things go well, the complainants may decide that it's okay for you to have contact at that location. All right, there's 100 hours of community service restitution. I'm going to order anger management. Once you've completed anger management, 50 of those hours will be deemed satisfied. And the remaining 50 hours will be satisfied once you've completed parenting classes. And I'm going to order parenting classes. Field visits 1 time per month for 3 months. And there's $1,000 fine, and that will be probated. And restitution is to be paid at $100 per month. Probation, is there anything else? No, there wasn't a request for a no contact with him. Just the address.
I have one more thing, Judge.
Yes.
What would you set the supervisory fees at? Set them at the minimum because of.
In regards to that, legally, now that they've changed things, she'll have to fill out a form. And once she fills out that form saying that she's indigent and provides proof, I'll receive notice of that, and then I'll be able to make a decision on that.
And can she get that form from probation?
Yes.
Okay. Thank
All
you.
right. And what I can tell you, supervisory fees, they help probation run their operations. Okay.
Okay.
All right. Is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yeah.
All right, we can go off the record. Here's the thing: to be successful on probation in this court, communication is key. If you have an issue, let probation know about it. If you feel they're not addressing it, you can always come back to the court and address it with me. Do you understand?
Yes.
All right, good luck to you. Make better decisions, okay?
Thank you.
All right, you're welcome. Thank you, counsel.
All right, we're creeping up on, oh, never mind. I was just about to say we're creeping up on. Oh no. Okay, she's back. So we're creeping up on lunchtime on the East Coast, and just as I was saying that, Judge Glazer got up and walked away. So I was going to stop and cut someplace else, but now she's back, so we'll go because I'm curious to see how she's holding up as we approach lunchtime.
Here, they're waiting for my courtroom to get finished. They're trying to redo the electronics there.
Mm. Yeah,
That's
they've been doing that on where we're gonna have our stations too.
Really? Oh, boy. Hopefully they work better. So corrections, you have the next case, Mr. Perez Dao. He may need a Spanish interpreter.
How may I help you?
Thank you.
And Judge, after this, I'm told that the mom is here for Mr. Suda.
Thank you. Good morning, Mr. Perez Dao. Do you speak English?
Buenos días, español. ¿Cómo está?
Sir, you were arrested for possession of cocaine and possession of drug paraphernalia.
Se le arrestó por tenencia de cocaína y tenencia de artículos para el consumo de estupefacientes.
I will appoint the public defender's office for you.
Voy a nombrarle a la Defensoría Pública para que lo represente.
There is probable cause for the charge.
Encuentro y determino que hay suficientes indicios de criminalidad para los cargos.
So, sir, you have an immigration hold as well.
Y le tengo que informar que también tiene una orden de retención por parte del Departamento de Inmigración.
So I'm setting a bond of $1,000, count 1, for possession of cocaine, and count 2, possession of drug paraphernalia is $500.
La fianza que le impondré en este caso será $1,000 por el cargo de tenencia de cocaína y $500 por tenencia de artículos para el consumo de estupefacientes.
Have a good day, sir.
Tenga un buen día, eso es todo.
Next is, we're going to need Mr. Ivan Garzón Rangel.
Who did you call next?
Oh, I'm sorry, Ivan Garzón Rangel. You want me, then I'll do your other client, okay? His bondsman is here. Good morning, sir. You were arrested for unlawful possession of 5 or more identifications, 2 counts of fraudulent use of a credit card, armed possession of cannabis, openly carrying a weapon. I will appoint the public defender's office for you. I need a moment to review the arrest affidavit for probable cause. So he's known to Macy's as stealing from them, I guess. So he made 2 transactions at Macy's totaling $719.74. He was trying to do a 3rd transaction and he gave some identification. And then he began acting suspicious by stating the credit card was his mother's and was looking in his wallet for something. Then he leaves the store in a hurry. The credit card used belonged to his mother. The name on the card was a Sergio Barliari. He had 11 different credit cards belonging to 10 different individuals, none which was on his name. So there's probable cause for unlawful possession of 5 or more identifications, 2 counts of fraudulent use of a credit card, armed possession of a controlled substance, openly carrying a weapon. You are ordered to stay away from the Macy's store at 1675 Meridian Avenue in Miami Beach, Florida. You're not allowed to go to that location, and you must stay away from that Macy's store. Do you understand, sir?
Yes, ma'am.
All right. Count 1, unlawful possession of 5 or more identifications is $2,500. Count 2 is fraudulent use of a credit card. There's 2 counts of that. It's $2,500, count 2. $2,500, count 3. Count 4, the armed possession of cannabis. You want $1 or an ROR, Ms. Corey?
ROR, please.
ROR count, I'm sorry, that's count 4. ROR count 4. Then count 5, openly carrying a weapon is $150. So, sir, you have a bondsman here and he'll get you out of jail. What?
Count
Count 6,
ROR,
possession of cannabis is an ROR. That's fine. Have a nice day. The bondsman will get you out of jail. Next we have is Reynaldo Rodriguez Martinez. Page 9. Morning, sir. I'm sorry, this is the other gentleman I passed of his mother here. Sorry, this is going back to Christopher Suda. You want to promote the victim?
She's the witness.
What?
She's the witness.
The witness, I'm sorry. Maybe the victim's witness? Someone's in here eating. His dress. Kids eat food and eat their wrappers. That's from the weekend. I should put a note for the weekend. Please clean up after yourself. So is she here or no?
I tried to promote her to a panelist.
I don't know why you're having problems. I'll do it. What is it under?
Miss Brenda, if you can accept, please.
I can do it without them having to accept. What is she under? The name?
Brenda?
MINSSU.
Well, that's my
Brenda's your mom, right?
yes, I'm Brenda, but that might be Minsu. That's my girlfriend. That would not be my mom.
So it's Brenda is his mom.
Brenda's my mom. Brenda Hammond is my mom.
Okay. Where is she?
I don't know. You told me she was here.
Miss Brenda, if you can accept.
I got her. I got her.
She's a little old. She but she can figure it out. Walk her through it.
Just because somebody's older doesn't mean they can't use Zoom.
You're around a bunch of older women here, so be careful.
That's why I'm involved in it. That's why I'm involved in the guardianship. That's because I try to help everything I can with my mom. So
Okay. Miss Brenda, are you able to unmute and put on your video? I did promote her. Let's see.
can you type to her or
Usually it works when I do it.
Someone's trying to help her at the bank. She's in a bank and someone's at the bank trying to help her.
Okay. Just have to accept the promotion as a panelist.
can you text on that app so that they see it on the bottom, like it's muted or no? So that even though they
It's
can't
not
hear you, they
muted.
can.
It's not muted. If Miss Brenda can speak, we might be able to hear her.
I don't see her.
She's declining to be promoted as a panelist. You got to accept the promotion. This is why I can't get out of here at a decent hour. My patience is going to run out soon, but not now, not so quick. I'm trying one other thing. I removed permission to talk and I'm going to go back and try it another way now.
I mean, you could try to call her on her phone too and let her know, because if she's on Zoom.
What am I, your secretary? No, I'm the judge. They need to come to court and be heard or they don't want to be heard.
Okay.
Judge, I don't know why we need to hear from the witness either.
Well, she may have relevant information. That's why I understand there's something going on and I'm happy to.
I can give you the.
I can pass it till she can get on. How about that? So I have to sit here and waste time when I have all these other people waiting. So she keeps declining to be promoted as a panelist. You have to accept the promotion. Say yes when it wants to promote you to be a panelist. Then we can hear from you and see you, or you can speak now. What's weird is even though it's not giving her that option to talk, maybe she wants to log on again. Something's going on where I don't see her microphone there. Maybe somebody at the bank will help her. Give it one more shot. We'll wait another minute. So is she back? Because otherwise I'm gonna take a little break and pass it and go back to my calendar. Do you see her back again? I don't see her, so let me go to the next case, and if she comes back in, we'll see if we can promote her, okay? Mr. Suda, have a seat, please. Next is Reynaldo Rodriguez Martinez, page 9. What? Oh, I skipped one. I'm sorry. Who'd I skip? Who? Paul Varade? Page 10? No, I didn't. I'm on Rodriguez. That's page 9, it says. Reynaldo Rodriguez Martinez. Good morning, sir. Do you speak English?
Spanish, please.
Sir, you were arrested for false imprisonment with a deadly weapon, aggravated battery.
Señor fue arrestado por privación de libertad con una arma mortífera, agresión física con agravantes,
Aggravated assault with a deadly weapon,
agresión con agravantes con una arma mortífera,
battery by strangulation,
agresión física mediante estrangulación,
and tampering with a victim or
y
witness.
manipular o interferir con un testigo.
So Judge, I think there's probable cause for kidnapping. The state's
Señoría, yo creo que hay suficiente indicios de criminalidad para el cargo de secuestro.
that we reset it in the afternoon so I can file a motion, or if Your Honor would let me, I can file a motion now.
Y si usted lo puede postergar para la agenda de la tarde, para yo poder entablar una petición, o si no me permite, lo haré ahora.
So, sir, can you afford to hire a private lawyer?
Señor, ¿usted tiene los fondos y puede costear a contratar un abogado privado? I can't hear him. I don't know if the kill switch is on.
Sí, sí, depende del precio.
Yes, it all depends on the prices.
Do you work?
¿Usted trabaja?
¿Puedo hablar más? Sí.
Yes. Habla
How
sin
much-
micrófono,
how
si no,
much
no
do
me
you make
oigo.
a week?
¿Cuánto gana semanalmente?
Bueno, ahora como unos 1,000, creo.
Well, right now around $1,000, I believe.
That's
Pero
a
mira,
week?
¿Eso por semana?
sí.
Do
Yes.
you own your home?
¿Es usted dueño de su propio casa, hogar o vivienda?
No.
No.
Do you have any dependents that you support?
¿Usted tiene dependes a los cuales usted dependen de usted o usted mantiene?
Sí, mi papá que está en México,
Yes,
Mi
my
abue-
father who's in Mexico,
mi abuela está en el hospital muriéndose de cáncer.
and my grandmother is in the hospital dying from cancer.
So you're not required to, you're not financially obligated to support them, and you earn too much money to qualify for the public defender's office.
Bajo la ley, usted no se le requiere mantenerlo a ellos y bajo los requisitos para la Defensoría Pública, usted gana mucho dinero para que se le nombre la Defensoría Pública.
So what I'm going to do is reset your case in the afternoon. It's probably best if you hire an attorney because the state wants the court to find probable cause for a kidnapping charge.
Porque voy a refijar esta vista para la agenda de la tarde y será más que recomendable que usted contrate un abogado porque la fiscalía quiere que se encuentren suficientes indicios de criminalidad y causa probable para el cargo de secuestro.
Yo podría hablar sobre eso.
Can I speak about that, Your Honor?
No, don't talk about the facts because anything you say can be used against you.
No hable de los hechos, porque cualquier cosa que usted indique está siendo grabado y puede ser utilizado en su contra.
It's best you speak privately with an attorney.
Lo mejor sería que usted hable de manera privada con un abogado.
So I'm going to reset this case for the afternoon for private attorney.
Voy a agendar esto para la agenda de la tarde para la conversación sobre un abogado privado.
And you're also ordered to stay away from the alleged victim whose initials are ASP.
Y también voy a emitir una orden judicial de que usted se tendrá que mantener bajo orden judicial, lejos y sin contacto de la víctima cuyas siglas es ASP.
No contact with the alleged victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No podrá tener contactos con las víctimas, ya sea contacto directo, indirecto, en persona, por escrito, por teléfono o a través de terceras personas.
No contact with the victim through social media or other electronic means.
No podrá tener contacto con la víctima a través de redes sociales o cualquier otro medio electrónico.
And you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times.
En todo momento dado tendrá que mantenerse más de 500 pies de la víctima, del hogar de la víctima, colegio de la víctima, lugar de empleo de la víctima.
Do you understand the stay away order, sir?
¿Entiende usted la orden judicial de mantenerse lejos y sin contacto, señor?
Sí, yo entiendo.
Yes, yes, I understand.
Okay, I'm
Yeah.
going to reset the case in the afternoon for
Pero
private
vamos,
attorney.
yo no le hice nada.
Voy a fijar esta audiencia para la tarde para ver o hablar en cuanto a la contratación de un abogado privado por parte de usted.
And also the state wants the court to find probable cause for the it should be an armed kidnapping or kidnapping while armed.
Y también para la petición o que la fiscalía quiere que este juzgado encuentre que hay suficientes indicios de criminalidad para secuestro a mano
So-
armada.
And I believe the state's going to file a motion for pretrial detention.
Y con toda seguridad también la fiscalía va a estar entablando una petición de prisión preventiva.
We'll see you later for the afternoon calendar. It'll start at 2:00 today.
Lo veré en la tarde. Esa agenda comenzará aproximadamente a las 2 de la tarde hoy, así que le veré después. Buen día por
Okay.
ahora hasta la agenda de la tarde.
Only the 9th and most of this. You'd have hold them both for the afternoon.
Venga,
Next
vamos.
we have is Paul Verandi, page 10.
He's a fugitive from Florida Parole Commission, no bond.
Thank you. I see Miss Brent.
All right, let's change it up. We'll go back to Judge Boyd.
Court is calling 2025 CR 007801, State versus Darlene Gonzalez. Can I have parties announced for the record? State.
Honor, good morning. Frankie Sandoval on behalf of Ms. Gonzalez.
And are you Ms. Gonzalez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Judge.
Are there any applications in this case?
Your Honor, you know what? There's an application for deferred, which I do not believe may be part of what's presented to the court. We may present that after we do the plea.
All right. And is it an application for deferred?
Yes, Your Honor.
Okay. Ms. Gonzalez, do you want the court to consider an application for deferred adjudication in this case? All right. Have you reviewed the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Gonzalez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She is, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,000 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Council, are there any such motions?
There are not, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, state offers states exhibit 1 in all attachments.
No objection, Judge.
State you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Your Honor, in the interest of justice, we would ask.
Anything you wish to say on behalf of your client?
Your Honor, Ms. Gonzalez presents herself here accepting responsibility and just wanting to start the process of putting this behind her.
All right, who is Kenneth Ray Jackson?
Kenneth Ray Jackson is a friend of mine.
All right, not your boyfriend?
No, he's not my boyfriend.
You don't have any children together?
No,
You don't live together?
no,
Do you have any children?
no, I don't.
All right, who do you live with?
Me, I live with my mom.
And when's the last time you had employment?
A year maybe. About a
Okay.
year.
Why?
Honestly, I don't have a reason really. It's I help my mom kind of just sick. She has kidney problems. And
All right, that's not employment. Yeah.
But yeah, I'm just constantly busy watching her.
So how are you all able to pay for house, the utilities and everything?
Well, my boyfriend pays everything for me.
Who is your
right now.
boyfriend?
Terry Jones.
And why were you driving a U-Haul with this friend?
With Terry Jones, I was not driving.
No, I mean, I'm talking about the other
okay,
guy, Jackson.
Well, honest, that U-Haul that we're driving, it was paid for by a friend of.
No. I'm asking, why were you in a U-Haul with this Jackson person if you have a boyfriend that you say pays for everything?
He was just a friend, and he was just helping me, like,
Helping you do what?
We're helping moving stuff
With what?
with the U-Haul.
No, I mean, why do you have a U-Haul? That's what I'm trying to understand.
How to move things around in our storage, like move from a storage to another storage, because we had to have our storage. I think out of our storage to another storage out.
I'm sorry, what?
We're moving from one storage to another storage.
Okay. Okay. All right, so this is what the court is going to do. There's $1,000 fine. That will be probated. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 40 days. There's to be no employment as a home health care provider or with minors. You're going to have to get a job.
Okay.
Field visits 1 time per month until further notice. 200 hours of community service restitution. 100 of those hours will be deducted upon completion of a theft course. Is there any issues with you with drug use?
No.
There's to be no contact with Kenneth Ray Jackson. Probation, is there anything else? Oh, I'm sorry, 4 years deferred adjudication.
Or do you want her to report to?
Where does she live? All right, how far is New Braunfels?
It's just like 45 minutes.
And is your mother living in New Braunfels?
Yes.
All right, Miss Abrams, is it possible to get field visits in New Braunfels by that probation office? And what county is New Braunfels? Do you want your probation transferred to Comal County?
No, it'll be fine here.
All right, she does not want it transferred. All right, is there anything else, probation?
No, ma'am.
Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. So here's the thing. How old are you?
I'm 32.
All right, so you're too old for this, to be doing this type of thing, and you're too old not to have employment. All right? So it's okay for you to help your mom, but helping your mom should not be you're bringing your boyfriend to live with you all. That's a no-no, because that's your mom's house, not yours. So you need to get employment so you can support yourself. You understand?
Yep.
All right, good luck to you.
Okay, thank you, Judge.
Thank you.
Okay, Ashley, I know what you think you heard. It's not that. I just looked it up myself, and I am dropping it in the chat right now so you can see how it's spelled. Let's go to Michigan, because we haven't been to Michigan today. This is Judge Elmore, and I believe the hearing has to do with some probation violations. Let's see what's going on.
7FH. Appearances from counsel, please.
Nick Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Medina. Mr. Medina appears by Zoom for court with us today.
Thank you. Mr. Medina appears via Zoom from the Wexford County Jail. Mr. Medina, are you able to see and hear the court?
Yes, Your Honor.
Thank you. Also before the court this morning is Mr. Sean Van Atten. He is the agent for the Michigan Department of Corrections, serving as the probation officer on this file. We are here today for a hearing on requests and warrants for probation violations in each of the two files. The requests and warrants were filed on the same date, August 14th, 2025. And they each include 5 technical allegations. All right, Mr. Harrison has told me that he had the opportunity to speak with his client, and anticipates a resolution. Mr. Carnes, what's going on?
Your Honor, it's my understanding that the defendant will be pleading guilty to count 1, count 3, and 1 of the other counts. And then the people will dismiss 2 counts.
It would be count 4, I believe.
Okay, so counts 1, 3, and 4 would be guilty, and the people will dismiss count 2 and 5.
That's in both files. That's a global resolution.
Are there any other terms to the agreement besides the guilty plea as to counts 1, 3, and 4?
No, I don't think so, Your Honor. There is some informal understanding between Mr. Medina and Mr. Van Attenville, but I think that's more, that's not court business, that's probation business.
All right, Mr. Medina, I'm told today you're going to plead guilty to 3 of the 5 alleged allegations. Is that correct, sir?
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. All right, Mr. Medina, I'm going to go over this. By entering a plea of guilty to 3 of the counts, you'll be waiving certain rights and not have a formal hearing. You'll be waiving the right to have the prosecutor prove the allegations by a preponderance of the evidence. You'll be waiving the right to have a hearing to question and cross-examine the witnesses presented against you, as well as the right to present witnesses, evidence, or testimony if you chose to do so. You also will be waiving the right to remain silent and the right to not have that silence used against you. Also, if your plea is accepted today, you will be resentenced on your original offenses for which you were convicted. In one of these files, file ending in 14066, you were convicted of unlawful driving away of a motor vehicle. That is a felony punishable by up to 5 years. And in the other file, you were convicted of attempted home invasion in the 3rd degree. That is a felony punishable by 2.5 years and up to $2,000. Now, these 3 allegations are technical allegations. That's important because there's a sliding scale as to potential punishment that the court may issue. For 1 technical, the court can give you up to 15 days. For 2, the court can give you up to 30 days. For 3, the court can give you up to 45 days. For 4 or more, there is no sliding scale. Mr. Van Atmel, have there been any prior probation violations in either of these 2 files?
No.
Thank you. One moment. Because I see these allegations, well, just a second. Because these 3 counts are technical violations, I believe the most the court is allowed to sentence you to or add to your confinement period is 45 days. I've taken a look at these 3, which are again 1, 3, and 4. I don't find that they are the same series of transactions of events. Each one of them had a particular individual objective. All right, Mr. Medina, now that I told you what, oh wait, I forgot to tell you which ones you pleaded to. Hold on. Count 1 alleges that you violated condition 2.4 by using methamphetamine on or about April 14th. That one, I'm told you're going to plead guilty to. Count 2 is an allegation to violated condition 4.25, which requires that you must report any police contact within 24 hours, and that you failed to do so on or about August 10th of this year. That one will be dismissed. Count 3 is that you violated condition 2.8, which requires you to complete outpatient or residential substance abuse treatment. And then as of August 14th, you had failed to do so. That one will be that one you're pleading guilty to. Count 4 is an allegation that you violated condition 4.22, and that requires you to follow all verbal orders of your field agent, and specifically that as of August 14th, you failed to enroll in mental health treatment as instructed. That one, I'm told you're pleading guilty to. And the last count, which will be dismissed, is an allegation that you violated condition 4.2. That requires you must not change your address without permission of the agent. And allegedly on August 10th of this year, you failed to notify the agent of a change of address. You understand what you're charged with and to what you're pleading?
Yes, Your Honor.
You understand your waiver of rights and how you will not have a hearing?
Yes.
And has anyone made any promises to you or threats to get you to plead guilty to these 3 of 5 counts?
No, Your Honor.
Has anyone made any promise to you as to exactly what the punishment or sentence would be from this court?
No, Your Honor.
Do you still wish to enter the plea as we discussed?
Yes.
As to counts 1, 3, and 4, how do you plead?
Guilty.
Before the court can accept that plea, the court must have you tell me what you did that makes you guilty of those 3 allegations. Now, before I ask you any questions, the court takes judicial notice of the terms and conditions of probation that are signed and contained in each one of these 2 individual files. They were both signed by this court and then subsequently acknowledged by Mr. Medina on June 30th of 2025. All right, Mr. Medina, is it true that you used some methamphetamine back on or about August 14th and you tested positive?
Yes.
And you knew that that was in violation of your probation terms?
Correct, yes.
Is it also true that you failed to complete residential outpatient or substance abuse treatment? I said that wrong. Is it true you
Yes.
failed to complete? All right, and so that would have been some kind of drug treatment. Okay.
Yeah.
And were you told by your agent about having to do so?
Yes.
And is it also true that you failed to enroll in any mental health treatment, which is different than drug or alcohol treatment? Is that true?
Yes, sir.
And did your agent tell you that you needed to enroll in some mental health treatment?
Yes.
Mr. Carnes, do you believe he's provided a factual basis?
Yes, sir.
Mr. Harrison?
I'm likewise satisfied with the record.
Mr. Carnes, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Harrison?
No.
And Mr. Carnes, do you believe the court is in compliance with Court Rule 6.445?
Yes, sir.
Mr. Harrison?
You are.
The court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. And the court further finds that the testimony provided by the defendant under oath on the record, in addition to the judicial notice taken of the terms and conditions of probation, and therefore finds the defendant guilty of counts 1, 3, and 4. Counts 2 and 5 are hereby dismissed. Can we proceed to sentencing today, Mr. Van Admiral? Mr. Carnes, any objection?
No, Your Honor.
Mr. Harrison?
No objection, Your Honor.
Mr. Medina, we can proceed to sentencing right now if you allow us. That's up to you because you have the right to be physically present here in the courtroom when there's a sentence. However, if you are willing to allow us to do it right now with you appearing via Zoom, we can get it done. What would you like me to do?
I'd like to pursue right now.
All right, got it. The court finds under the statutes and court rules that the technology is appropriate. Mr. Van Etten.
There's 2 dockets, Your Honor, and all the information I'm going to provide is the same on each docket.
Okay.
He has, as of this date, not counting good times, 62 days jail credit.
Okay.
He owes $798 on each docket. I believe 0 payments made. Sentencing guideline range is 0 to 11. On each docket, I would recommend 105 days jail credit for 62 days served. Not be opposed to release to inpatient treatment if that's is eligible. Probation continued without.
Mr. Carnes.
Thank you, Your Honor. In both of these files, but especially in the home invasion, where the victims knew the defendant, there was concern of serious substance abuse problems causing all of this. So the violations are concerning. I think Mr. Van Ackenmel's recommendation is reasonable. I'd ask the court to follow it. Thank you.
Harrison?
He's only been on probation since I think June 25th in both matters. That's why I think what I hear Mr. Van Admiral saying is I want him to cool it for a few days in jail, and I want to get him back on track because this is a kid that we could lose pretty easily if we don't keep better supervision of him and have him close by where we can keep our eyes on him. So I don't disagree with the sentiment that he's expressed. the jail time that he's proposed is within the allowable, if you will, amount of time under the new version of the statute. I don't really have a solid objection to any of it because ultimately, I think Mr. Van Atmel has a good plan. And now it's up to Devin to avail himself of it. Thank you.
Thank you. All right, Mr. Medina, you have the right to make a statement today before the court issues a sentence. Is there anything you wish to say before I issue that sentence?
No, Your Honor. No.
All right. All right, the court issues the following sentence. Despite there being an intermediate sanction cell, the court reaffirms its sentence from the, reaffirms the reasons for the sentence last time discussed on the record. The court sentences the defendant in each one of the two files as follows. Probation continues as previously issued by this court. I reaffirm the terms and conditions that were contained in the PSI and that were contained in the order of probation. The court preserves all fines and costs, and the court sentences the defendant to 110 days in jail with 62 days of credit. Obviously, with good conduct time, that should put him at 77 days. So he'll have about a month left to serve. And of course, if there is a request to release him early because Mr. Van Atmel is able to get him into a treatment program, the court will of course sign that as I want to see him get into the treatment. All right.
Thank you.
The court also reminds Mr. Medina that we do have services there at the jail. Anything further, Mr. Van Atmel?
No, Your Honor, thank you.
Mr. Carnes?
No, Your Honor.
And Mr. Harrison?
Nothing from us, Your Honor. Thank you very much.
Mr. Medina, you should be getting at the jail 2 copies of 1 document. You would have received these last time, but I have to give them to you again. You have the right to appeal the conviction and sentence in this case. While that is typically done by filing a claim of right to appeal when someone's been convicted at a trial, based upon the plea, any appeal must be done by filing an application for leave to appeal. Now, the form that you're going to get, the first one you will place your initials on, merely acknowledging the receipt to the other copy. That other document is the form that you fill out if you request an attorney to be appointed to help you file an appeal. If that's what you want, then you must return that form back to this court within 42 days. Now, if you choose not to appeal, you may simply dispose of that piece of paper. There's nothing magical about it. Do you understand?
Yes, Your Honor.
Do you have any questions, Mr. Medina, about what we have done today, sir?
No.
Thank you. We are adjourned. Thanks.
Thank you.
Okay, friends, let's go to Louisiana. I haven't been there today.
We're here for the revocation hearing on Darren Neely. Mr. Neely, will you introduce yourself, record, and DOC number?
How you guys? My name is Darren Neely, 595-864.
Okay, and Will, you're represented by Ms. Tessa Silverman. Ms. Silverman, would you introduce yourself for the record?
Good morning. My name is Tessa Silverman. I'm representing Darren Neely.
Okay. Okay. The way this is going to go, that I'm going to read some information to the record. I'm also going to read your violations. You're to plead guilty, not guilty, with or without a statement. And then after we do that, we will let the people speak on your behalf. You have Brian Lars, Orleans Public Defender's Office, Tasha Trahan, Ant, and Tessa Silverman, attorney, that will be speaking on your behalf. Okay, do you understand?
Yes, sir.
Okay, do you have your parole questionnaire with?
No, sir.
Okay, would you, questionnaire, please? Okay, is that your signature?
Yes, sir.
Okay, so that shows that you're not eligible for appointed counsel, but you've already retained counsel. So are y'all ready to proceed?
We are, yes.
Okay. It is alleged that you violated the condition of you failed to refrain from engaging in criminal activity as evidenced by your arrest on 4/3/25 by the New Orleans Police Department for the charges of domestic abuse battery involving strangulation and domestic abuse battery child endangerment. How do you please, these charges were refused by the New Orleans District Attorney's Office on 5/30/25. How do you plead to that?
Not guilty, sir.
Okay, could I have a statement later? All right, well, we'll get to that when, after we hear from your speakers. Okay, Mr. Lars with the Public Defender's Office.
Yes. Good morning, board members. My name is Brian Lars. I'm a social worker with the Orleans Public Defender's Office, and I've been working here for about 6 years. One of the most important things that I want to express to the board is that as a social worker, my responsibility to public safety is the same as this board, and I take it very serious. So, like, even though Mr. Neely's charges were refused, I still took the necessary steps to address any underlying issues. So as you, if you have a copy of my reentry plan, you will see that I referred him to Cater Recovery and Prevention, which is located right here at 2601 Tulane Avenue on the 9th floor in this building, to address any underlying issues like any anger issues, domestic violence issues, and also to help teach Mr. Neely coping skills. And I also referred him to First 72 Plus, where he can also benefit from working with individuals over there, going to peer support groups and things of that nature. He also have access to this office on a daily basis, access to me to help him work through difficult situations. And also, I've met with Darren on several occasions, and he's been able to express remorse for past previous behaviors. And what I mean by that is that he has some infidelity issues and some promiscuous behaviors, which has caused some problems in his current relationship. He's been in a relationship with this young lady for 9 years, and they have a kid together. Darren have several other kids, and he'll talk about those things. And we just hope that the board consider the facts of this case and give Mr. Neely the opportunity to get back to his kids. The kids need him. He has about 6 kids, and so we hope that you consider this plan. I'm going to be actively case managing this case, and the work that I do will be, complemented by other social workers and client advocates here at this office. Thank you.
Okay, then we're going to hear from Latasha Trahan, your aunt. Okay, Ms. Trahan, what did you want us to know?
Good morning, everyone. I'd like to piggyback off of Mr. Lance's statement in regards to having multiple kids with different women. I do believe that some of those situations sets him up for a failure with communication, whereas I think that the girls will get, to arguing with each other, get him involved. I will say Darren is a resilient person who, despite his challenging past, he has integrity. He loves his family. He loves his kid. And I was talking to him a couple nights ago in regards to a plan when he comes home. He had a job before this situation happened, and he expressed concern about obtaining a TWIC card, and I support him with all of his endeavors. I'm hopeful that the board, will grant him permission to obtain a TWIC card to kind of travel if that's an opportunity. New Orleans is a really hard place to heal if that's what, where you have to live. It's kind of tough. He's been here all of his life. I've been a support system for him. Darren has a strong work ethic and he's genuine. Though he's faced struggles in the past, he is determined to be there for his kids, to be supportive, but life has tested him. I just hope the best for him, and I'm here, I'm his aunt, I'm willing to help him, even changing his living situation. I think that if he remove himself from the situation, if the relationship is dissolved, to remove himself from the situation in lieu of having to have an address or whatever he may need, to prove to the parole board, I have a home where Darren can live with me and my family. I have a son that's 29 years old, and I have 4 bedrooms there. There's an extra 2 bedrooms. He can live there. He doesn't have to be put in a situation that's potentially dangerous, and I help with his, with his future success.
Okay, thank you, ma'am. Okay, and now we'll hear from your attorney.
If it's all right, honorable members of the board, I would prefer to reserve my statement until after Mr. Neely gives his. Is that permitted?
Usually, we hear from the attorney before, and if they have something.
That's fine.
To say after the hearing.
Okay, that's completely fine. Thank you. So what I want to say, I guess, a few points. One is, I imagine you all have had the opportunity to review some of the evidence in this case. Of course, we didn't have a chance to receive full evidence because the charges were refused, but I've seen the body-worn camera that I imagine you've seen of the complaining witness being interviewed in the ambulance, and I've read the initial police report, and I can imagine, because I've experienced it firsthand, that those are very kind of difficult things to witness, and there's a strong emotional response from seeing those things and seeing this woman who is clearly hurt being interviewed in an ambulance. And it's my initial instinct watching that was, oh my goodness, this is a horrible thing that happened. Somebody needs to help this person. And I think that that's a legitimate and noble emotional response to have to that evidence. What I would say is that when I had an opportunity to step back and look at the picture from a more kind of logical and rational perspective, and with the additional information of the letter that the complainant, Ms. Alexander, asked to be able to provide. To be clear, I did not reach out to her to ask her to write this letter. She is insistent that she wanted to provide this new information to the board. I do think that as sympathetic as this situation is, the evidence simply is not there that Mr. Neely was the one who was directly responsible for the injuries that Ms. Alexander sustained. For example, she makes pretty severe allegations of strangulation that are documented in the police report, multiple instances of it, but you hear on the body-worn camera, the EMT saying that he does not see any signs of strangulation around her neck or her chest. She also alleged at the time that she was dragged by her hair through the street, and this would have happened in the middle of the day. But it does not seem that any neighbors told police that they saw anything like this, nor did police recover any, surveillance footage or Ring doorbell footage from the area that shows that kind of event, which would have been pretty notable to happen in the middle of the day in a neighborhood. So all of that to say, not that something didn't happen to Miss Alexander, because according to her letter, something certainly did. She did get into an altercation with one of Mr. Neely's other children's mothers. And then she had an understandable emotional response to that. And in anger at Mr. Neely for his infidelity, which she had learned about through that incident, she made pretty extreme allegations against him that are not supported by evidence. And almost as soon as Mr. Neely was arrested, she started reaching out to us to kind of express her regret for putting him in that situation and explaining that she wanted to undo what she had done. And that is, I think, why we have this letter now. I also would understand if the board felt concerned about the veracity of this new letter, and concerned that perhaps she is fabricating things now in order to achieve the outcome she is now hoping for, which is for Mr. Neely to be released. And to the extent that that's true, if that is, I think what that leaves us with at the end of the day is still a witness who says things that are not true based on whatever objective she has in that moment. And since her word is the only thing connecting Mr. Neely to this alleged offense, if her credibility is that much in question, I think that even more underlines why it would not be fair and it would not be just to punish Mr. Neely for these allegations. Taking a step back, I want to just talk for a moment about Mr. Neely and what I've learned about him, getting to know him through our time working together. I find him to just be a very impressive person. One of the first things that I learned about Mr. Neely is that he's got significant learning disabilities and didn't know how to read or write until his 20s. He only finished 6th grade in school, excuse me. And he taught himself to read and write while he was incarcerated at the Department of Corrections in his 20s, so that he could write letters to people on the outside. And the way that he did that, which I think is so interesting, is he would take songs that he had memorized where he knew the lyrics and look up the lyrics and then find the words where he knew them to be in the song and teach himself how to read and write those words in that way. And I think that story just really signifies his persistence, like Latasha was saying, how hardworking he is, how dedicated he is to achieving his goals. And he'll tell you when he has a chance to speak that his goal now is to put himself on the right track to avoid, putting himself in situations like this one in the future by behaving more responsibly in his relationships, to be a dependable father to his children who mean the world to him. And Mr. Lars has come up with a really, I think, amazing, thorough plan to help him achieve those goals. And I know that Mr. Neely is able to follow through on that based on his work ethic and his commitment. So thank you very much for your consideration.
Yes, a question. Yes, you said earlier that she was dragged during the day.
That's what is alleged in the police report.
Right.
Dragged back in the house.
She jumped out the window and she was dragged back into the house.
During the day?
Yeah, during
the daytime.
The girlfriend saying why they didn't see the girl. Well, I'm asking that.
Okay.
I'm sorry?
One of the statements that Ms. Alexander wrote, she said she planned on participating on Zoom today, but I don't see her on Zoom. You know why she's not here today?
I don't know.
Okay. All right, let's move on with the hearing. Your case has been assigned to Mr. Tillis. Mr. Tillis, do you have any questions?
Yeah. Mr. Neely, what happened?
What happened, I can't really speak for what happened because I wasn't there. I was told at a later time what took place, but like I said, I wasn't really there. I was just told, I was briefed on the situation. This was after everything took place because literally the same day, me and her was together.
Please tell me the truth. Were you walking around the house? You were seen walking behind the house. You're saying you weren't there?
No, sir.
Then she's lying?
She's not telling the truth.
This is a neighbor now. This is witnesses. This isn't your fiance.
They said I was seen behind the house, maybe when I went there, but as what was going on, no, I wasn't there as it took place.
Okay.
They said they seen me. It wouldn't be uncommon for somebody to say they seen me at my house.
Okay. Okay, I got a couple of questions. What about the son?
My son? That's not her child.
Okay, did he try to get involved or try to stop you or anything?
No, my son doesn't live with me. My son lives live with his mom.
I got you. Okay. All right. I have no further questions. Is the panel ready to vote?
Yes.
Okay. Bid, Mr. Tillman.
My vote is to revoke because of rule violation number 4.
I'm going to concur with the same reason the body can't put out that evidence pretty. And I concur, my colleagues, today your probation has been revoked. You'll get a letter when you reapply.
Can I ask you guys a question?
Denied.
It's okay. Keep your head up.
We'll see you soon, okay?
Okay.
That was perfect how okay, keep your head up came in right after the denied. I love it. Let's do this. Let's go to Battleground, Washington. Judge Wheeler. We'll see what's going on up there today.
Have you had plenty of time to talk to Mr. Sowards?
Yes.
Do you need any additional time?
No.
From the paperwork here, it shows that you are 40 years old. Is that correct?
Yes.
What's the highest grade in school you've completed?
Highest are 12.
Okay. Are you able to read and understand the English language?
Yes.
In entering a plea to an amended charge of DUI no test, you are giving up some rights associated with the DUI refusal charge. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial, and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt. You enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. Do you understand those rights, sir?
Yes.
You understand that in pleading guilty today, you're waiving or giving up those rights?
Yes.
The charge that you are pleading to in the state of Washington is called a gross misdemeanor. It is subject to 364 days in jail and a $5,000 fine. There is a pretrial agreement that I'm holding up. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Yes.
Court can place you on probation for 5 years, during which time you'd pay cost, fees, and assessments as authorized by law. There's also a special portion here that talks about things that are not discretionary, meaning the court does not have any ability to modify or change these things. Box J has been checked. Do you understand that there is a mandatory 90-day license suspension upon entry of the plea?
Yes.
Do you also understand at box Q that there is mandatory sanction inconsistent with the DUI attachment that has been submitted with your case? Do you understand the court cannot go below those guidelines?
Yes.
To the charge of driving under the influence no test taking place on August 1st, 2025 in the city of Richfield, Washington, how do you plead?
Guilty.
Are you entering the plea freely and voluntarily?
Yes.
Has anyone made any threats or promises to get you to plead guilty?
No.
So, Mr. Sowards, I think I understand that the outcome is the same, but because the plea that's being entered is to a no test.
I was going to bring that up, Your Honor. The statement of defendant, I had written that out prior to receiving everything, and it said a 0.08 or higher. That should say that he was appreciably affected from intoxicating liquor or alcohol.
I'm going to modify slightly Mr. Sowards and Mr. Lester, and I'm going to read it and then see if the parties agree. My statement reads, on August 1st, 2025 in the city of Richfield, Washington, I operated a motor vehicle at a time that I was appreciably affected by intoxicants. Upon contact with law enforcement, an evidentiary breath test was not conducted. Is that sufficient for the parties?
No objection on behalf of Mr. Lester, but I would ask that he acknowledge.
Mr. Lester, is that consistent with what took place?
Repeat that?
So I was asking you if the statement I read was consistent with what happened. I will read it again. It states on August 1st, 2025 in the city of Richfield, Washington, I drove a vehicle while appreciably affected by an intoxicant. Upon contact with law enforcement, an evidentiary breath test was not conducted. Is that correct statement?
Yes. Yes.
All right. Court will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Go ahead, Mr. Sowards.
Thank you, Your Honor. Mr. Lester has a change of plea date for August 27th to take care of his Vancouver charges. The court is aware that he is currently under a Colorado fugitive that he has waived extradition on. We are asking the court to follow the pretrial agreement with the 10 days credit for time served. He has served more than that at this time. We would also ask under the Blazina analysis to note that Mr. Lester is in custody, has been in custody, and will in the future continue to be in custody for some time, and that any discretionary fines, fees, or costs with the court should be waived.
Mr. Lester, is there anything you would like the court to know, sir?
No.
Okay. I will follow the recommendation of the parties. Count one, 364 days in jail with 354 days suspended, leaving 10 days to serve. Credit for 10 days. Sentence is suspended for 60 months. $5,000 fine with all 5,000 suspended. I am finding pursuant the Blazina analysis that Mr. Lester is indigent and unable to pay. Conditions of sentence. Again, as I stated, bench probation for 60 months. Mr. Lester is to obtain a substance use disorder evaluation and comply with treatment within 60 days. To attend and complete a victim's impact panel, also within 60 days. We are going to schedule a review date on the case. I understand that Mr. Lester might not be in state for that. Well, at that point, we'll be reviewing the substance use disorder evaluation, recommended treatment and victims panel. That hearing is going to be on the 26th of November, 2025. That's going to take place at 10 a.m. You can be in person, sir, or on Zoom that day. But if you are not incarcerated, you do need to be present. Do you understand?
Yes.
Okay. All right, if there's nothing further, that concludes your hearing. Thank you, sir.
Thank you.
Good luck, Mr. Lester.
Thank you.
All right, let's bounce back to Judge Boyd. So this will be a follow-up. We have a video on the channel, and I'll put it in the chat, involving a defendant named Frank Garza. Now, Frank, as I recall, he was homeless. He had some felony stuff going on. And he was found in possession of a gun. He claims that he called 911 because he found the gun and he was trying to get it turned in, but that's not what the prosecutor believed. So he's back in court right now, and let's see where this is going.
Hey, I'm Frank Garza.
Judge, I'm here, and an hour ago, I was told that no 911 tape existed, and now she just said they got it and they're uploading it. This is the one that we started this 2 weeks ago, and you didn't want to take the plea, and we reset it so we could try to get the 911.
Oh, yes. No, I remember this case.
And so she just said she got it, she's uploading it, so if we could recall this.
Yes,
I can at least.
because that hinges on everything.
Absolutely.
So, do you all want to recall it for Monday or Tuesday?
Either one's fine. Tuesday's probably better for me.
All right, Norma, can you set this for August 26th?
Yeah.
All right. We'll bring you back on August 26th. You're welcome.
Okay, not much of a follow-up, but an update at least. Now we know what's going on. I've marked down the 26th, so we'll follow up there as well. But The people on that video will be happy because the only thing in the comments is when are you going to post a follow-up. Well, there it is, guys. So we'll link that in the video. Let's go back to Judge Wheeler, I suppose. Yeah, let's go there.
Took place in 2024, theft in the third degree. Looks like Ms. Wiegand missed court in the month of November. Court had issued a warrant at that time. Ma'am, your attorney, Mr. Wallace, is with us here in the courtroom. Go ahead, Mr. Wallace.
Thank you, Your Honor. We're asking to maintain a not guilty plea and address release conditions.
Okay, not guilty plea is maintained. Ms. Carmi, I'm not seeing anything in the file. Is the state making any requests regarding Ms. Wiegand's release?
This was an add-on, Your Honor. So when there was a new felony charge just yesterday, she was seen in Clark County Superior Court. My understanding is that she was released on that case and it's set for next appearance to September 3rd. The concern for the city is that it appears it's a burg and theft from the same shopping center in which she is supposed to have no contact under our case. So we are asking for some manner of bail, even $1,000 to remain. She has a warrant history with us, 4 prior warrants. This case is almost a year old and she has not reappeared. And now we have a felony that appears to me, and I don't have the report, but it appears to me to have been with the same victim company as our case.
So I guess 2 questions for me.
Yeah.
First, on the Superior Court matter that you're referencing, was there bail imposed in that matter?
No.
Okay.
No bail. And it's 2 counts of burg 2, 2 counts of theft 3.
Okay. And I guess the only other question, you said the same shopping center. Yeah. Is this the allegation taking place in Rosars?
That is my understanding.
Okay. Mr. Wallace.
Thank you, Your Honor. We're asking the court to release Ms. Wiegand to enhanced release. She was previously ROR'd on this case, but as the court indicated, there was an alleged failure to appear back in November of last year. The prior warrants, I believe, aside from the one, relate to driving while suspended cases from 21 and 20. And correct me, okay. Ms. Wiegand is, as the court I think is aware, is a longtime Clark County resident, practicing attorney, at least was practicing law since 2005. She lives in Ridgefield, has stable housing with her partner and partner's mother in Ridgefield. My understanding is this is her first time in custody. And so that in and of itself, I think will be a wake-up call to her as to the importance of making future court dates. And so we're asking the court to give her another shot out of custody, but we'd understand that some amount of supervision with enhanced release would make a lot of sense. Thank you.
All right, so Ms. Wiegand, the following are your conditions of release. You are to violate no laws, appear at all mandatory court dates. You're to notify the court of any change of address or phone number. You are to have no contact with Rosauer's stores. I'm going to place Ms. Wiegand on administrative release with Clark County pretrial release. Administrative release, ma'am, is just a telephonic check-in. Certainly, as you can imagine, if there is a future non-appearance in this case, next time we will be imposing bail, but I am going to give you that option one final time.
Thank you, Your Honor.
We're going to set 2 future court dates. The first is going to be an attorney pretrial date. That's going to be on the 3rd of September, 2025. That's a date just for Mr. Wallace. Ms. Wiegand, your next mandatory court date, ma'am, is going to be on the 9th of October, 2025. It's going to be at 10 a.m. You can be in person that day or on Zoom, but you do need to be present. We're going to get you some documents over at the jail. And once you have your paperwork, you are free to go. Thank you.
Thank you so much, Your Honor.
May I call an out of custody 10 a.m. case, Your Honor?
Yeah, absolutely.
Thank you. Case number 4A and 45.
Thank you for doing that. He was here quite early, so.
Yeah, thank you, Your Honor, for
Yep.
hearing it. This is a driving while suspended in the 3rd-degree allegation. We're asking for a set over to November 13th, if I'm not mistaken, with a speedy trial waiver set to commence that same day.
Mr. Kutsar, have you been able to talk to Mr. Wallace about your right to speedy trial?
Yes, I have.
Do you understand in doing a waiver commencing November 13th, you're giving the city of Battleground 90 days from that date if it became necessary to bring you to trial? Are you okay with that?
Yeah.
I want to find you're making a knowing, intelligent, and voluntary waiver. Your next mandatory court date, sir, is November 13th, 2025. Any previously imposed release conditions remain in place. We're going to get you some paperwork, sir, at the far desk by the door. And once you have your documents, you are free to go. Thank you.
Thank you.
Ma'am in the front row, what's your name?
I'm Linda Perez.
Okay, Ms. Perez, if you want to come up to the podium, please. Ma'am, if I can have you state your name and date of birth, please, for the record.
My name is Linda Perez and my date of birth is 8/21/78.
Ms. Perez, you're making a first appearance arraignment today, ma'am, on a controlled substance knowing possession charge. That charge in the state of Washington is a gross misdemeanor. It's subject to 180 days in jail and a $1,000 fine. I did review the associated police reports with the case. I did find what is called probable cause. Because this is a criminal charge, ma'am, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today for a court-appointed attorney?
Yes, please.
Okay, I'm going to ask you some questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
Yes.
Okay, what's the nature of the assistance?
I lost my home almost 2 years ago, and so I just now got approved for housing through VHA. And
Okay.
so I've been working with an advocate, with a victim advocate, to get me back on my feet.
Sounds
And so it's been a pretty tough road, but I don't have an income right now, but I'm working on it.
Sounds good. Court will assign in regards to court-appointed attorney, Ms. Landwehr. Court will assign Steve Sowards. Ms. Perez, we're going to enter a not guilty plea today, ma'am. That preserves all of your rights and keeps all of your options open. I'm going to assign 2 future court dates. The first is just for your attorney. It's called an attorney pretrial. That's going to be on the 3rd of September, 2025.
Okay.
Your next mandatory court date, ma'am, is going to be on the 2nd of October, 2025. That is going to be at 10 a.m. Can be in person or on Zoom that day, but you do need to be present. The attorney to your right is Mr. Sowards. He's the gentleman who's going to be representing you. Your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You're not to consume or possess any alcohol, non-prescribed drugs, or controlled substances while your case is pending. I am releasing you at this time on your recognizance. Mr. Sowards, do you want to have the file?
Yes, please.
Okay. So ma'am, you're going to get some documents here shortly. Also allow you to connect with Mr. Sowards before you leave today, okay?
Okay, thank you so much.
I've talked to Ms. Carmi.
Okay.
Yeah, Mr.
Yeah. Okay.
Okay, thank you. Thank you, Your Honor.
Thank you. Have a good day, ma'am. Gentleman on the aisle, what's your name? What's your name? Mr. Sue? Your case is on at 10 a.m., so we'll get it called shortly though, okay? Thank you, Mr. Sue. Good morning. How are you? Hi. Ready to head back to school?
All right, friends, I don't think they're going to be getting to much else there fairly soon. We're only a couple of minutes away from the top of the hour, so I think we'll call it a day. I hope you had fun today. I did. We had a lot of good laughs and some interesting court, and I enjoyed it. So we will be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar, where I am joined by Ashley and Bailey and Michael, where we will discuss topics. I don't think we've settled exactly what we're going to talk about, but it's law stuff, it's court stuff, and it's a good time. If you want to hear somebody other than just me, and you just might, join us for Sidebar, 8 a.m. Pacific, or 8 a.m. Eastern rather, 5 p.m. Pacific, and we'd love to see you there. In the meantime, go have yourselves a great day, and of course we'll be back tomorrow at the usual time. But go make it a good Thursday, and we'll see you soon. Take care. God bless.